May 20 also. In item 21, let's say I am going to file my reply. So that maybe I have to bring that
Today you are going
today.
item number 21.
21.
Oh, that was fixed on today only.
Yes,
no?
Lordship.
Oh, yes. Okay.
May please, Your Lordship. I beg to mention item number 22, Lordship. With the consent of other side, Lordship, matter to be taken after 2 weeks. Lordship.
Have you taken consent?
Yes, Lordship.
You are for the appellant or respondent?
Appellant, yes.
List of the court.
Obliged.
May please, Your Lordship. I beg to mention item number 10 and 11, tagged matter, Lordship. Lordship, learned senior counsel A.C. Sharma is absent today due to his personal difficulties, Lordship. Consent
10 and 11.
10 and 11. Consent from the petitioner has been taken.
Mahunta.
I am for a petitioner, Lordship. He is for respondent.
Oh, you are for the respondent. So for whom you are appealing?
Lordship, learned senior counsel Mr. A.C. Sharma. Lordship, actually, I am on behalf of Mr. B. Devi. He was supposed to mention the matter, but due to his baby's medical issue, he has not here now.
Whatever, you are for on behalf of H.C. Sharma, you are appealing.
Lordship.
For respondent number 1 and 2.
Lordship.
Pardon. Okay. Yeah. But 1.
After 2 weeks, Lordship.
Obliged.
May please, Your Lordship. Lordship, this matter was heard. One judgment I like to give. I have given copy to the other side. The judgment is reserved, Lordship. I am giving one judgment only. That may be kindly.
Have you, I mean, case number is
Everything I have given.
May I please, Your Lordship.
yes.
This is the Dharamtul case from Morigaon.
Item number 2 is one of the bail hearing matter, so case diary is available with us. Item number 1 and 2
For 2 case diary is available.
available. So 1 is also
So it is the motion stage, we can fill the case diary.
yes,
diary.
because my lord 1 and 2 same
Out of
PS
the
case.
same, out of the same
Yes.
case, Lordship.
Yes.
And three petitioner before your Lordship, my lord, as on today, my lord, 74 days behind the bar. So, my lord, we are praying that considering the length of detention, my lord, they may be allowed to go on bail. My lord, 14 days police custody was taken by the police, interrogated. My lord, ample opportunity was, my lord, taken by the police. So, my lord, further interrogation may not necessary at this stage.
74 days.
74 days, my lord.
Otherwise, my lord, sufficient incriminating material against. They are directly involved in hijacking of the truck and they are looting of the.
One thing I just want to ask you, there are 2 sets of accused, most probably.
Yes.
One is directly involved in
Directly
hijacking the
involved.
truck.
Yes.
And the other where the
purchase,
vehicles were
well,
unloaded or purchased or
purchase.
whatever. So now these
But
three
these
are
accused persons are directly involved.
directly involved in
Directly
hijacking.
involved, yes, hijacking of the truck. And Babul Ali also, my lord, item petitioner, now, he is one of the own vehicle was also used, my lord, at the time of commission of the said offence, my lord. That is, my lord, page 19, forwarding report is also specifically mentioned about his vehicle number. My lord.
That's why I'm asking. Otherwise, it's 74 days.
Yes, sir.
Is there any note of the IO that further investigations for the purpose of
Otherwise, investigation substantially progressed. Some of the persons are already, my lord, but my lord, from the case that there are sufficient materials otherwise against these accused persons. They are along with other accused persons, my lord, one Suburuddin and one Mystery is also there. Along with them, they actually, my lord, plan make the entire plan along with one Suburuddin for hijacking of the truck and thereafter looting of those articles. And in which all these Babul Ali, Buddhuddin and Jural Ali, well, from the initial point of time, they are involved. along with the main accused person.
So substantial progress is there, but the question is that whether further custody because same kind
Because further custodial, because some of the, my lord, because total amount, total Erica nuts, total 15,000 kg,
Till
value
now,
is of
yes.
37 lakh 8,000. But all Erica nuts not yet recovered. My
My lord, imposing conditions, they may be allowed to go on bail. 74 days,
And
my
is
lord.
there any other cases pending against him?
Against
Same
this,
kind of.
against these persons, my lord, from the case diary, I have not found any cases. But in item number 2, they were death accused. In one another case is pending against him.
72, it is the 90-day offense. Is there any note from the IO that the charge sheet may submit within a short period or almost ready? Is there any such kind of?
Actually, my lord, case diary is here in from last. Here, last note of the IO is 18/3/24.
I don't think I can take a note from the IO. Is there any whether charge sheet is already because CD is there?
Because the CD is here.
Out of 78, there's nothing. We don't have any.
Yes.
If it is there, it is note or anything that charge sheet is going to cut within a particular.
No, regarding that, my lord, there is no such.
Hard
Care of, my lord.
how they are the 40 days of I got okay. Yes, what there that about I have accepted from I that right or but because appropriate to take some direct uh, to reduce quantity of artistic because of the that get to take the of the and the their topic is that to uh, the some quantity of the for it but wait when
My lord.
Ending before?
CJM Morigaon.
Other one is number 2 is fixed for one Jiarul Hawk.
Ziaul Haq, yes.
Oblige.
Ziaul Haq, he is in this case shown arrested on 4/3/24.
And Lordship already grant that case.
20.
4/3/24. Earlier arrested in Mornoi PS case number, same number, 8/24 under section 380 411.
71 days.
Case number is same, Dharamtul PS case number 8 and here Mornoi PS case number 8.
That's why we think that
Yes,
because of the case number the same.
yes.
Now he is also involved directly in
Yes, he is also involved and my lord, one Caesar list, page 27, on being leaded by the present accused person from his my lord,
Purchaser, Lordship.
uh,
He was purchaser.
page 20.
page 27 of the petition, my lord. From his campus, my lord. After his arrest, my lord, on being leaded by him, those Erika nuts were recovered from his house.
Quite a good number, good amount of Erica nuts.
Yes, sir. And from the case there, it is available that by by digging his art, my lord, from his house premises, those Erika nuts were recovered.
By the art.
Yes.
But Lordship, he is not hijacker, Lordship, and he purchased the same Lordship from the other.
Purchasing is thick, okay. But why he dug all the Erica nuts?
Kept under the ground.
Yes,
No,
yes.
no, Lordship, no.
Those are
These are the Lordship and
already
the
recovered from the by digging his art of his house.
well, recovered Lordship.
Hmm?
Recovered Lordship.
Yes, recovered. But that so that he claimed himself to be the purchaser. No. As per his submission, he was a purchaser.
Initially, he claims to be the purchase, but immediately after my lord hijacking the truck and my lord looting of those articles, thereafter my lord unloaded those Erika nuts in his house.
So as per you, he is not a purchaser.
In fact, he's because those Erika nuts why unloaded, well, thereafter from his house premises, those Erika nuts were recovered. As per his statement, my lord, he stated that he purchased. If he purchased, there is no reason to, my lord, hide those Erika nuts.
Yeah.
Earlier, my impression was also that he was a purchaser.
Artist.
F.
F. F. F. Okay. Artist. Artist. Both particular of both how Okay. From 50 was it the police custody? No,
No,
he was not at
not.
all. But how to pay for to and but 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 and and the recovered around one 1668 cases of heroin from outside the Cape Concept. And I the 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 not that but to keep uh, and to think bona fide but all from house but and a good quantity and a good quantity of the for further extension not but it for and don't and it but up for and okay
Hello. Published, published, published.
again back I very much
May I have your lordship? Lordship, my signature 11, court number 1. Lordship, matter will adjourn for the time being. You will appear in
My
this.
lord, my prayer is that as we are appearing for in the test appeal for respondent number 1 to 4, and they have filed this IA to implead respondent number 5 as a party in the case. So my prayer is that we have to take instruction from the client. Maybe fix after
Lordship, we have
one
some, my senior will appear in this case because it's very important, Lordship. My senior will appear. So after some time, Lordship, he will appear in this case.
obliged.
May I please allow you? Here in this case, on the last occasion, the matter been fixed today.
My affidavit has not
Come?
arrived. So matter will be taken up at 2 lordship. If
affidavit has come already.
no.
Affidavit is only with regard to denial. Okay? It can be taken up at 2 law.
May I have your lordship?
This appeal is filed by the Railway Union of India. The appeal is under Section 23 of the Railway Claim Tribunal Act against the judgment and order dated 13/9/2011 passed by the Railway Claim Tribunal in OA number 1216 of 2007, allowing the claim of the respondent applicant as a compensation of rupees 4,23,109 along with the interest, my lord, for refund of this collection of the overcharge paid on incorrect distance and the punitive charge for overloading of the wagon in violation of the provision of section 72, 73 and 78 of the Railway Act, my lord. As well as the para 1878 of the Railway Commercial Manual Volume 2, 1991. Lordship, kindly see the Annexer 1 as page 17. This is the judgment. May I read, Lord? Page 11, page 18. According to the applicant of the appellant, a train load consignment of cement was booked on 18/11/2006 from the Vishnupuram to New Guwahati under invoice number so and so. But the respondent collected freight on distance 2478 km instead of correct freight charging distance, that is 2360 km, and the collecting freight charging rate of which is rupees 1693.40 per metric ton. However, the applicant has stated that the respondent has collected excess freight of rupees 2,90,756 as undercharge at the destination station on the plea of overloading fund en route. Notice under section 1006 served by the applicant to the respondent. Thereafter, the applicant filed a claim petition in the RCT Guwahati bench, stating therein that respondent is fully liable to refund freight overcharge and undercharge with the cost and interest. The para 2, the respondent filed a written statement raising certain objection that claim application received by them is found without date and signature of the applicant. Thus, it is not maintainable. The RCT has no jurisdiction to decide the instant case of penal charges. That freight is in question was paid at the booking station at Vishnupuram under the South Central Railway, and hence the Honorable RCT Guwahati bench has no territorial jurisdiction to try the case for refund of freight overcharge, and that the applicant may directed to appear in person before the Honorable Tribunal to establish his identity, authority and address with supporting documents. That they do not admit the claim notice issued by the KP Maheshwari advocate on behalf of the applicant without power of attorney legal authority as the blade claim notice, and the penal charges was paid by the applicant in the destination, but the freight was paid by the consignor Pama Cement Industries Limited at the booking station at Vishnupuram. The payment of the consideration money as well as the railway freight to the consignor by the consignee is their internal matter, is not accountable in this case, and the applicant without any legal authority from the consignor is not entitled to get the refund of the freight overcharge, that is the overloading of wagon was detected at the Women en route at the weighbridge of the RKI Adra, and accordingly the destination station NGC New Guwahati realized the penal charges on the basis of the aforesaid women chart observing prescribed railway rules. The railway administration have every right to reweigh the consignment at the time before delivery, and the consignment was not weighed at the time of booking. That the railway receipts were issued on the basis of the weight declared by the sender in the railway receipt. The remark was given to the women en route or destination or to collect undercharges according to the wagons were weight en route at RKI Adra weighbridge found overload, and destination station raised the penal charges as per the women chart of Adra. That the weighbridge of the RKI Adra was found in working order at the time of weighment of the subject wagon. As such, it is not possible to determine that there is no excess loading by mere counting of the bags at the time of delivery. and the applicant did not raise any objection before delivery of the consignment at the destination station regarding the penal charges and therefore paid for dismissal of the application with cost. This is the statements of the railway. Now, after hearing the parties, some issues are framed. There are five issues are framed. Whether the notice under section 136 of railway take or served properly by the applicant to the respondent in time. The two, whether the applicant holds legal right for the claims. Now, three, whether the respondent proved that they have charged freight on correct distance and so they are not liable to refund the undercharges collected by them at destination point. Whether the applicant proved that they have overcharged at the booking point as well as destination point, if so, whether they are entitled for the compensation, either what relief and what cost. So, on that issue, the RCT, after verification of the all documents, decided issue number 1 in favor of the respondent claimant that notice under section 106 is maintainable. Now, issue number 2, notice was served by Messrs. Ariane International. This is a consignee. The claim application filed on C12/2007 in RCT Guwahati Bench has been stamped and signed by the director for Messrs. Ariane International Limited under verification. This is to confirm by the applicant in their affidavit. As per railway receipt, the consignee is the Ariane International. Therefore, the title is in order. Issue number 3, this is the main issue, my lord. As per railway receipt, distance from the Vishnupuram to New Guwahati is 2478, whereas according to information supplied by the CCM FM PIO headquarters commercial NF Railway Exhibit A31, the chargeable distance from the Vishnupuram to NGC is 2357.35 km, rounded off 2358 km. CCM Southern Railway, via the letter dated 19/6/2007, Exhibit A26 has also admitted the error in distance. Freight rate for distance slips from 2351 to 2375 as per goods tariff number 44 part 2 freight rate table in force from 1/7/2006 is 1693.40 per ton. Exhibit A33. As it is proved that the respondent did not realize the freight from the applicant on correct basis. The applicant stated in the application that the respondent realized the penal freight 2,90,756 by money receipt number so and so against excess weight rejected at Way Bridge at Adra. This amount was paid by the applicant under the protest Bhait letter dated 23/11/2006. Respondent was requested by the applicant to verify the backs of the accounts of their uniform size by consulting the delivery book and unloading tally book by their letter number so and so. Payment was done on 20/11/2006 at Adra. No prior information was given to the applicant as per verification certificate issued by the office at Collector of Metrology, West Bengal, Exhibit R3. The Way Bridge was inspected on 5/5/2006 and validity up to 5/5/2007. This validity up to 5/5/2007 has no relevance with the proper working of the Way Bridge after date of the verification. The counsel of the applicant pointed out that the Way Bridge of Adra is unreliable as the weighman chart shows that a wave of the brake van at serial number 41 as a 0.00. This fact is proved on appraisal of the weighman particulars. This applicant relies upon the Honorable Tribunal judgment and order dated by the division bench applicant so and so and relied on the judgment so and so. The Railway Act Section 73 has the power to levy penalty on the basis of the rehuyement done in the absence of consignor, consignee, endorsee. Held penalty can be levied on after issue of show cause notice to the person from whom penalty is thought to be recovered. And after affording a reasonable opportunity of pleading in this case before the competent authority who is going to levy the penalty, complies with the principle of natural justice emphasis. Para 8 of the judgment as it is so. So far as the power of rearmament is concerned, same is available with the railway. After when it comes to the question of levial penalty on the basis of the rearmament which has been done in the absence of concern or consignee endorsee, we are of the opinion that penalty can be levied on after issuing show cause notice to the person from whom the penalty is sought to be recovered, and after affording him a reasonable opportunity, placing his case before the competent authority who is going to levy the penalty. The punitive measures of resulting of actual penalty can be exercised by the authority only after following the principle of natural justice and not to the basis of any evidence which may have been collected by railway expertise at the behest of the consignor, consignee, endorsee. Payment done by the respondent was unilateral without giving any information to the applicant. This is a deprivation of natural justice. In view of the above relied upon judgment, it is proved that railway are not eligible to collect under charges from the applicant. The applicant has stated in the application that no excess goods were loaded by them and no excess goods were delivered to them. And the respondent has also failed to disclose the booking or delivery of the excess load by the applicant. It remains that respondent has failed to clarify this fact. Hence, respondent is liable to refund of undercharge collected by them to the applicant. The issue is in favor of the issue therefore decided against the respondent. Issue number 4. Issue number 3. Since the issue number 3 is decided against the respondent, and the issue number 4 decided in favor of the applicant. Now, my lord, and with the direction was granted to make payment of the 4,23,109 to the applicant with the interest at the rate of 6% per annum from the date of filing of the application to the bank account. So now the railway challenging this judgment on the various grounds. As I have stated in my, I have taken a ground, my lord, in para 5 in my page 4 of my memo appeal, para 4, 5, 6, 7, 9, 10, 12, 13, 20, 21. Now, in my ground number 5, the respondent in its above claim petition challenged the collection of the freight on distance 247 km from Vishnupuram to New Guwahati instead of correct freight charging distance 2360 km at a correct freight charging rate of which rupees 1693.40 per metric ton, which were collected by the competent authority of Vishnupuram, that is forwarding station or booking station under South Central Railway. So, my lord, this charges for distance was collected by the South Central Railway, not by the NF Railway. So, they have collected on 18/11/2006 to the extent of rupees 1,32,353 without proper jurisdiction. Further, the respondent applicant challenged the payment made at RKI Adra Way Bridge at Enroad on 20/11/2006 and the collection of penal charge under section 73 and 78 of the railway at destination station NGC to the extent of rupees 2,90,756 from the consignee and the respondent applicant at the time of delivery of the consignment due to overloading on the ground that no notice of payment was issued to them. As such payment is bad in law, collection of penal charge, punitive charge at destination station NGC is refundable by railway is in violation of section 72, 73, 78 and 79 of the railway. So, my lord, if they are aggrieved with the charge of the railway overloading before delivery of the consignment, the consignee, it is the overcharge was detected at under Southeastern Railway, and for distance the freight was collected by the Southeastern Railway, South Central Railway, Secunderabad. Now, if they are aggrieved, as per the payment chart, NF Railway is collecting the penal charges. So, if they are aggrieved with the overloading of this consignment, they could approach to the railway under Section 79 of the Railway Act for reweighment of the consignment prior delivery of this consignment. But no such request was made to the railway under Section 79 of the Railway Act, and they paid the penal freight as charged by the railway without any protest. After making payment of the penal charges without requesting for reweighment of the consignment under Section 79 of the Railway Act, now they are, after taking delivery of the consignment, they are challenging the collection of the punitive tax and freight on distance. Already they have paid without any protest. Now, my lord, in ground number 4, for the learned RCD failed to consideration that claim application had been filed by the respondent applicant by way of claim of refund 1,32,356 paid in excess at Vishnupuram under South Central Railway on account of incorrect distance from the Vishnupuram to NGC, and punitive charge over charges under charges accounting to 2,90,000 before the RCT by including the General Manager NF Railway and the General Manager South Central Railway as a respondent number 1 and 2 without valid cause of action for invoking of proper invalid jurisdiction. Since for the collection of the distance, wrong distance, it is collected by South Central Railway from the consignor. It is the duty of the consignor to challenge the railway has collected wrongly. There are a number of railway claim tribunals in Indian Railway in different zones, my lord. So, since the Southern Railway collected this overcharge, then it was the appropriate forum is the RCT Southeastern Central Railway. But without their filing the claim application before the South Central Railway, they are claiming the compensation by filing claim application before the NF Railway. NF Railway already collected the penal charges on the basis of the overweight found at South Central Railway. So, my lord, in this case, a dispute belonging to the one zone cannot be entertained by another railway zone on the basis of the Section 74 of the Railway Act. However, the learned RCC entertained said claim of the respondent even after preparing written statement by raising objection by the appellant petitioner respondent number 2 to avoid unnecessary litigation expenses, inconvenience and embarrassment. Now in para 9, my lord, ground 9, for that present case, the consignor booked the consignment at Vishnupuram for New Guwahati, and the complaint authority of the South Central Railway collected the freight to the extent of rupees 1,32,353 on a distance of 2478 km from the Vishnupuram to New Guwahati. At Vishnupuram, that is the forwarding station, booking station under South Central Railway. On 18/11/2006 from the consignor. In view of the above, the respondent applicant, being the consignee, shall not be entitled to claim refund of the said overcharge in respect of incorrect distance collected by the South Central Railway by preferring claim application before the Railway Claim Tribunal and NF Railway. This is the violation of the jurisdiction as provided under Section 1063 of the Railway Act 1989. Moreover, no application of the respondent applicant before the learned RCC shall lie against either South Central Railway or NF Railway on the ground that consignee or endorsee is not legally entitled to receive such a refund of freight overcharge as provided under Section 108 of the Railway Act. Now, my lord, already in para 10 also, I have taken the same ground that since the Southeastern Railway collected the freight, and the penal charge was collected by the NFRA on the basis of the payment made by the South Central Railway. So the railway claim table has no jurisdiction of Guwahati bench to entertain this application. Now, my lord, in para 12 of my ground, for that so for collection of the penal charge, punitive charge, and under charge, etc., from the consignee at New Guwahati under NF Railway is concerned, the learned RC failed to take into consideration that requirement at RKI Adra Railway way bridge for way verification by South Central Railway and found that the state consignment was overweight, and accordingly, state South Central Railway charged penal freight under charge for the late payment, as same was collected by NF Railway as per decision of the South Central Railway, because it is destination station is under NF Railway. As the railway vested the power to measure way reamendment of loading, overloading before delivery, there is no provision for issuing notice for the purpose as provided under section 73-78 of the Railway Act, as well as a part 1, 2 of the situation A, B of the Schedule of Notification 23/12/2005 Institute of Ministry of Railway Board. Para 1878 of the Railway Commercial Manual, Volume 2, as well as under the provision of Rule 3 of the Railway Punitive Charge Overloading Wagon Rules 1990 and 2007 as amended. So, my lord, in this case, there is one case of the Honorable Supreme Court, the Jagjit Katang Textile Mills versus Chief Commercial Superintendent Northern Railway, reported in AR 1998, Supreme Court 1959. The decision of Honorable Gujarat High Court in the case of Gujarat Salt Manufacturing and other versus Union of India are reported in AR 2010 NOC 556 to Gujarat. The appellant further relied on the decision of Honorable Rajasthan High Court in the case of Rajasthan State Mines and Minerals Limited versus Union of India and others reported in AR 2009 NOC 250 Rajasthan, wherein the Honorable High Court observed that altered remedy by filing complaint before railway rate table is raising dispute of punitive charges. Now, my lord, now railway rate table is already amalgamated with their railway claim tribunal. So, railway, any punitive charge is collected by the NF railway claim tribunal, any railway claim tribunal can entertain the claim application. Now, here in this case, since the South Central Railway collected the freight with the consignment, on the basis of their payment, I have collected this freight as that it is a destination under NF Railway. So, I am not responsible. The South Central Railway is the responsible for finding out this overweight as well as collection of the freight on a distance. So, though they have made here respondent number 1 as South Central Railway, their jurisdiction is in Secunderabad. So, under the railway claim tribunal Secunderabad, not NF in the railway claim tribunal Guwahati bench. The Secunderabad bench will entertain this claim application to be filed by the consignor. The consignor has paid. Now, without making any claim application by the consignor, the consignee is filing this case with violation of the section 74 of the Railway Act. Moreover, when the consignee taking delivery of this consignment, if they are aggrieved, they could have approached to the railway as earlier I stated under section 79 of the Railway Act. But no such question raised before collection or delivery of the punitive charge by the NF Railway. They, without any protest, they paid. So, my lord, in section 21 also, now they are raising the way bridge was not in working condition on that period when the women were, but they failed to produce any evidence. Without any evidence, the way bridge was not in working condition. It is the electronic way bridge. If not in a working condition, it is burden lies on the applicant who is claiming it is not working. There is no evidence. Now they are saying that there is no overload. There is no any evidence for authentication of their claims. There is no overloading. The women chart is wrong. There is no. If they fail to produce any evidence for authentication of their claim by giving any invoice or sell invoice for the how much consignment was booked and how much was overweight. The railway collecting the freight as per declaration by the railway consignor, how many bags or how much weight has been booked, and according to on the basis of their declaration in forwarding note as under section 64 of the Railway Act, railway issuing the railway receipt and collecting the freight. So in such situation manner, now the RCT observed that and relied on the decision of the RCT and the High Court. There is a violation of the principle of natural justice. But in judgment, RCT observed everything in this case. But the RCT have not framed any issue regarding the violation of the principle of natural justice. So, since they have not raised any issue, this matter cannot be entertained, my lord. Because issue is only whether they have charged the freight on correct distance or incorrect distance, whether there is a overloading of the consignment or not, whether railway collected penal freight or it is refundable to the applicant or not. But violation of the principle of justice is not framed here, my lord. Now the RCT, on the basis of the decision of the Supreme Court, High Court, the panel can be levied after issuing show cause notice to the person from whom penalty is sought to be recovered. Now, relying on the decision of the judgment also that before collection of the penalty, show cause notice is required to be observed. But as per section 73, 78 and decision of the Honorable Supreme Court, when consignment was on, railway has complete power to measure this consignment at en route at booking station or destination station. So accordingly, they were the consignment.
Your NF railway is not supposed to be for this.
Yes, ma'am. So I
penalty
yes.
As was the charter for the person.
Yes, madam. So, madam, there are a number of decisions, madam. If not this feel necessary, I can cite the decision, madam. There is a Supreme Court decision in reported in AR 1998, Supreme Court 1959. This is in favor of the railway. The question of issuing show cause notice does not arise. The section 74 deal with the effect of railway receipt and transfer the liability of the consignor to the consignee. It is under section 74, passing of the property in goods covered by railway receipt. The property in consignment covered by railway receipt shall pass to the consignee or endorsee, as the case may be. The delivery of the said railway receipt to him, and he shall have all rights liability of the consignor. So, in our view, the contention are not tenable. It has been noticed in our discussion in point 1 and 2 that railway statutes define maximum carrying capacity, normal carrying capacity, and the permissible carrying capacity. No wagon can be loaded beyond the maximum carrying capacity. The wagon could not ordinarily be loaded beyond the normal carrying capacity or up to upward variation thereof, and the limit is called permissible carrying capacity. Section 73 of the new Act and Rule 161A of the old rule permits loading in excess of the permissible capacity carrying without any penal charge. Now up to limit of 2 tons. What is now subject to penal charge is the excess over and above permissible level and stated in always below maximum limit. Now there is provision in under section 72, there is a maximum carrying capacity, and section 73 has the power to charge the penal charges for overloading. Section 78, there is no any provision for issuing any show cause notice either when it was done at en route or destination station. But main point is that this issue was not framed by the RCT. So this point cannot come in this case. So this point deal with the relief of the court should prohibit levy collection of penalty charges under section 73 Act, rule and so. In much as we have hold that points 5 and 6 as well as point 7. These penalty charges can be collected from the consignees or endorsees of the railway receipt under the new Act and Rule 1990, whereunder petitioners are not entitled to any direction against the railway for in future. This is the decision of the Supreme Court. Railways power. They can waive the consignment and they can collect the penalty charges. If they are not agreed with these penalty charges, before delivery of the consignment, they can revert the consignment in their presence under Section 79 of the Railway Act. This is the Supreme Court decision. And the provisions of Indian Railway Commercial Manual, para 1878, punitive charges for overloading of wagon, Section 73 of the Railway Act lays down where a person loaded goods in wagon beyond his permissible carrying capacity as exhibited under subsection 2 of or subsection 3 or notified under subsection 4 of Section 74, a railway administration may, in addition to the freight and other charges, recover from the consignor, the consignee or the endorsee, as the case may be, charges by way of penalty at such rate as may be prescribed before the delivery of the goods. This is the provisions of the Indian Railway Commercial Manual. These are the judgments. पूरा सा My lord, there is so many judgment, my lord, of this honorable court, my lord. Power to measure and weighment of the consignment. Discretion of the railway to reweight the consignment on en route at the destination before giving delivery of the consignment to the consignee endorsee. When reflected in the railway receipt is subject to weight, which may be found on reweighment provided the same is correct prior to reweighment. No notice is required to be given to the consignee endorsee, which is relied on this honorable court. This case is reported in 2003 to GLT and relied on the decision of this honorable court, reported in 1999 3 GLT. My lord, in there is one railway claim tribunal RCT. The railway claim tribunal also itself observed that decided this issue of the collection of the punitive charges, where it is observed that the opportunity was this RCT also passed the judgment relying on the decision of the various judgment of this honorable court and found that when the case is viewed in the backdrop of the principle of natural justice, I am of the opinion that there is no violation of the principle of natural justice in case where the applicant could have asked the railway to reweigh the consignment when demand for punitive charges were made for overloading. By demanding the same, respondent offered an opportunity to the applicant to show cause, if any, why he should not be directed to pay the sum. If there is no overloading as contested by the applicant, it could have requested the respondent to reweigh the article as required under Section 79 of the Railway Act. An authority can only afford an opportunity. In this case, opportunity was afforded. It was for the applicant to avail it. Applicant did not avail of that opportunity by requesting for rearrangement. If the applicant was so sure that there was no overloading, he could have requested the respondent to reweigh the article, and by rearrangement he could have established his case. A person who did not avail of that opportunity and a person who could have proved that there was no overloading cannot be heard to say the principle of natural justice is violated. If the person who is not visually handicapped refused to see, he alone needs to be found fault in such a situation. This is a decision of the Railway Commission. So, my lord, I am submitting all the decisions, my lord. It is easy. So, my lord, item number 7, the same condition, my lord. 6 is different. 6 is only said to contain the shortage of the consignment. 5 and 7 is the same.
Same.
Yes, same matter. 5 and 7. This is also under South Central Railway. A woman was done at RKI Adra. Now collection is made at NF Railway.
7 is
5 is, my lord. This is the consignment book to the remark under section 65(2) of the Railway Act, where the under section 64, the concern is required to fill up his forwarding note for declaring the how much consignment has been booked, and according to their declaration, railway is collecting freight and issuing the railway receipt and allowed to
now you see the letters are similar is 5 and 7.
5 and 7.
5 and 7. But 7 is along with one another item of 8. But the 8 is on
My lord?
one another item is on 8.
Yes, ma'am. In item number 8 also same matter, madam, but I am not in this case.
5, 7 and 8 the thing is almost similar.
Similar. 5, 7, 8 similar. But Mr. D.K. Dey is in this case, my lord, but he is not in this court. I don't know.
And which item?
My lord?
8.
8, item number 8.
Mr. D.K. Dey is
Yeah, I am not in the item number 8.
okay. Let us hear her reply on 5 and 7. Then
Lordship, I am appearing for item 7 only.
I,
Oh, sorry, 5.
5. So in 7, they it's not it.
In item 7, A girl is there, but my name is not there. I am not appearing in this case.
In 7, you are not appearing.
No. Brief is not with me.
I don't have the thing. Okay, we hear 5 now.
Lordship, first of all, pursuant to order dated 12/3/2024, a direction was given to the parties to file a written argument. So, Lordship, I would like to furnish this written argument before Lordship. May kindly bear with it.
Written argument. So, my lord, I have not brought this written argument, my lord. I will submit my written argument within.
Since her submission was already made, my lord, so now again.
If lordship permit me to file a written argument, then 2-3 days time may be granted, my lord. I will file written argument in item number 5, 5 and 7.
Argument, you basically have made your oral submission.
Already I have submitted, my lord.
Since there is a direction, that's why, my lord, I would like to. Now, my lord, first of all,
Item 5 to 10.
my lord, here there are mainly two issues involved in this case. First issue is that the railway had wrongly realized realized freight, my lord, excess freight, on account of incorrect distance. They have charged, my lord, freight for a distance of 2478 kilometer instead of 2358 kilometer from Vishnupuram to New Guwahati. And this is a admitted position. They have admitted this fact that the correct distance should be 2358 kilometer. They have admitted through their letter dated 19/6/2007, as well as, my lord, another exhibit is A31. So it is an admitted position, my lord. They have admitted that they have realized the wrong freight on the basis of wrong distance, my lord. So there is no dispute on that. That is decided in issue number 3, my lord. And the relevant document which lordship I would like to draw your kind attention, that is exhibit A26 and A31. It is in the LCR, my lord. We have made both the parties as respondent before the Railway Claims Tribunal, Guwahati, my lord. Respondent number 1 is NF Railway and respondent number 2 is South Central Railway. Since the freight collecting railway is South Central Railway, so we have made them as respondent number 2. And at destination, they have collected panel charges on account of overloading of the goods. So we have made them as party respondent number 1. So in the LCR, my lord, lordship may kindly come to the exhibit A26. A25 and 26. It is an information obtained under RTI, my lord, and the NF Railway.
Well, can you tell us which exhibit number?
A25 and 26.
A25. Yes, yes.
So, my lord, A25 is the information which we have obtained from the NF Railway under RTI Act 2005, and 26 page exhibit A26 is the relevant letter 21/7/2010, lordship, under serial number 4. They have admitted that from Vishnupuram to New Guwahati, the distance would be, my lord, 2358 kilometer. Lordship, got it? This is their admission, NF Railway admission. There is a letter dated 21/7/2010. Like
22, 23, 24.
25, then next one is 23.
26.
Yes, 21/7/2010. Letter.
that part.
I have flag marked my green flag.
It's 831.
Green flag, my lord.
Green flag is written 831.
831. But here in my file, my lord, it is written as 822. So, my lord, this letter is issued by the respondent number 1, NF Railway, and they have made an admission that from Vishnupuram to New Guwahati under serial number 4, my lord, that the distance should be 2358 kilometer. And in the railway receipt, my lord, this railway receipt was issued at the time of booking, my lord, booking the consignment. So there they have charged 2478 kilometer. Almost more than 100 kilometer they have charged extra. So, my lord, they have made this admission that they have realized a wrong freight. And again, my lord, 19/6/2007, this is the letter issued by the freight correcting railway, that is South Central Railway. They have also admitted that, my lord, may kindly see letter dated 19/6/2007. So, they have said that, my lord, with reference to your letter cited above, you may kindly refer to this office letters of event number dated 23/24/4/2007 and 31/5/2007, wherein you were asked to submit a letter of authority in your favor from the consignor Mrs. Penna Simme Industries Limited VNUP in order to process your claim for refund of such and such paid access at VNUP due to error in distance. So, my lord, they have demanded us to furnish letter of authority from the consignor, because, my lord, this freight was imposed upon the consignor, this extra freight. So therefore they have asked us to furnish a letter of authority from the consignor in our favor, so that they can process this amount in our account, my lord. But, my lord, here the requirement of letter of authority is not mandatory, my lord, because as per section 74 of the Railways Act 1989, my lord, the consignee, I am the consignee, my lord. So the consignee has the title to claim for the refund of freight overcharge. They have the rights and liabilities of the consignor. If lordship may see section 74, it is clear, my lord. Section 74 of the Railways Act 1989 clearly says that, my lord, may kindly see 74. It says the property in the consignment covered by a railway receipt shall pass to the consignee or the endorsee, as the case may be, on the delivery of such railway receipt to him, and he shall have all the rights and liabilities of the consignor. Since, my lord, they have collected excess freight from the consignor, but by virtue of section 74, my lord, I have the title to claim for the refund because I am the consignee, and section 74 allows me to claim for the refund. So accordingly, I made an application before the RCT as well as before the railway administration. So this is my submission with regard to the title, my lord. And my lord, here 19/6/2007, they have clearly admitted that this is the amount we will going to process in your account, but before that you need to furnish letter of authority. So my lord, we cannot furnish that, we did not furnish that letter of authority, and therefore they did not process our amount, my lord. So this is the submission, my lord. So here, my lord, in with regard to the issue of distance, my lord, both the wings of the railway, that is NF Railway and SC Railway, they have admitted this position that they have realized wrong freight on account of incorrect distance, my lord. So this is an admitted position, and the learned RCT Guwahati is rightly dealt this matter based on these two documents, my lord. And the second issue they have raised before your lordship is that jurisdiction, my lord. So, my lord, the freight collecting railway is SC Railway. So their stand is the booking railway, that is Vishnupuram, has the jurisdiction to entertain this type of claim application. But my lord, as per Rule 10 of the Railway Claims Tribunal procedure, may kindly see, my lord, Rule 10. They have this rule allow us to file application, my lord, in two places, one at booking or at destination. Lordship may kindly see Rule 10. Rule 10 of the Railway Claims Tribunal Procedure Rules 1989. My lord, Rule 10. Here the, my lord, legislature provide us place of filing of the claim application. One is at the place where the payment was made, and another where the destination station lies. So here the destination station lies within the zone of NF Railway, because, my lord, they have collected panel undercharges on account of overloading of the goods from the consignee. So, my lord, we have preferred this claim application in RCT Guwahati. In Rule 10, my lord, they have also made a reference of Section 13, I guess, my lord, Section 13. So, conjoint reading of Section 13(1), they have also provide us the place for booking also, my lord. Lordship, if lordship says Section 13 of the Railway Claims Tribunal Act 1987, so conjoint reading of both the sections, so the legislature provide us three places for filing of the claim application. First is the booking station, second is the place where the payment was made, and the third is the destination station, my lord. So here, in the present case, destination station is NF Railway, so we preferred our claim rightly before the Railway Claims Tribunal, Guwahati bench. So this is my submission with regard to jurisdiction, my lord. And my lord, they have also raised a point that we have paid the amount, that is undercharges at the bookings at the destination station, so far as overloading is concerned, my lord, that we have paid without any raising protest. So, my lord, we have raised this protest, and our protest letter is also available in the LCR. We have paid the amount under protest, my lord. This letter, lordship may kindly see 23/11/2006. 23/11/2006. Lordship, it will, lordship, marked as Exhibit A22. Lordship. The subject is undercharge payment of rupees such and such against RR number such and such. Reference is your money receipt number such and such. Dear sir, with reference to the above, we would like to inform you that we have made the payment of rupees such and such under protest matter. So we have raised our protest before making this payment, my lord. So our protest is there, my lord. Second, another thing they have raised, my lord, that before taking delivery of the goods, we did not made any request for repayment under section 79. So, my lord, my submission would be section 79 says that, my lord, if the consignment booked under owner's risk rate, my consignment was booked under owner's risk rate because it is a cement consignment. So, if it is booked under owner's risk rate, my lord, then repayment shall not be allowed, my lord. No repayment shall be allowed. My lord, may kindly see section 79. Section 79. (79) says, payment of consignment on request of the consignee or endorsee. Also got it? A railway administration may, on the request made by the consignee or endorsee, allow payment of the consignment subject to such conditions and on payment of such charges as may be prescribed and the damage charges, if any, provided that except in cases where a railway servant authorized in this behalf considers it necessary so to do, no payment shall be allowed of goods booked at owner's risk rate or goods which are perishable and are likely to lose weight in transit. So, my lord, here the present consignment was booked under owner's risk rate, and that your lordship may kindly see from the railway receipt that lordship will find from the exhibit R6. R6, my lord. There are total two railway receipts, my lord, R6 and R5. R5, R6. So here there is a column, my lord. There is a column risk rate. So here it is mentioned as OR. OR stands for owner's risk rate. Exhibit R5 and R6 in the LCR, my lord. It is the document filed by the railway, my lord. These two documents, R5 and R6. Yes, R5 and R6. Lordship, R5 and R6 are two railway receipts, and this railway receipt was defined under section 65 of the Railways Act 1989. And railway receipt is considered as a prima facie evidence of the weight. And here there is a column risk rate, my lord. So here it is mentioned as OR, and this OR stands for owner's risk rate. So my stand is, my lord, that since the consignment was booked under owner's risk rate and under proviso to section 79 provides that no payment shall be allowed if the goods booked under owner's risk rate, then this question of making any request for repayment does not here, my lord, arise, my lord. This is my stand, my lord. So far as, my lord, they have realized this under charges, that is, my lord, 2,90,756 on account of overloading of excess goods. This, my lord, consignment was reweighed at Adra. Adra is an intermediate station which was under Southeastern Railway, not under South Central Railway. So, because there is no payment facility at the booking station, so the railway weighed the consignment at an intermediate station, that is at Southeastern Railway, Adra, and they have weighed this consignment on 2011-2006 in absence of the applicant, my lord, the respondent. So, my lord, they did not issue any so-cause notice before levy of penal charges. So here there is a law settled by the honorable full bench of this honorable court, my lord, and it is a settled law that before imposing any penal charges, they have to issue so-cause notice to the party, my lord. So this is a law settled by the honorable full bench of this court, my lord. That I will provide it, lordship, later. And it is also mentioned in my written argument also, my lord. Lordship can see that judgment placed by me at page, first is at page 10. 10 is 1995 3 GLT 548. Para 8. Relevant page is 12. This is the judgment rendered in the case of the Union of India versus Messrs Salt Marketing Center. And relevant paragraph is at page 12, paragraph 8. Have you got it? As stated above, as far as the power of rewaivement is concerned, the same is available with the railway. However, when it comes to the question of levying penalty on the basis of rewaivement, which has been done in the absence of the consignor, consignee, _C, we are of the opinion that the penalty can be levied only after issuing so cause as to the person from whom the penalty is sought to be recovered and after affording him reasonable opportunity of placing his case before the competent authority who is going to levy the penalty. The punitive measure of realizing the actual penalty can be exercised by the authority only after following the principles of natural justice and not on the basis of any evidence which may have been collected by the railway ex parte at the back of the consignor, consignee and authority. And the same judgment was relied by the RCT Guwahati, my lord. Under issue number 3, my lord. Issue number 3, internal page 4, my lord. Last paragraph in the impugned judgment, my lord. This judgment was relied by the RCT at paragraph second last paragraph, my lord. This there that the applicant relies upon this honorable tribunal judgment and order passed by the division bench in application number such and also relied upon the judgment of 1995 3 GLT 548 given by Honorable Guwahati High Court in writ appeal number such and such. And after this, my lord, again the Honorable Court in writ appeal number 333/2010, my lord, at page 14 of my written argument, they have rendered this decision, my lord, and the relevant paragraphs are para 11. I have already marked it, my lord. So these are the relevant paragraphs, and it says that so-cause notice is mandatory before imposing penalty, my lord. After that, my lord, again at page 20, and I have also enclosed few more judgments, my lord, in analogous appeal, MFA 59/2015. Here the senior counsel is there, my lord. She has made a submission that before levying a penalty, a so-cause notice is mandatory. Lord, she may kindly come to page 24. Ms. Chakravarti has submitted that the appeals were filed on the ground that there is no requirement in law in terms of section 73 of the 1989 Act to issue any notice. However, Mrs. Chakravarti fairly submits that the court in writ appeal number 333/2010, Megha Technical and Engineers Private Limited versus Union of India, had held that before recovery of penal freight under section 73 of the 1989 Act, an opportunity must be provided to the consignor to establish why punitive charge should not be made. So she fairly submits that it is required under, my lord, this section 73. So this judgment passed in writ appeal number 333/2010 is applicable in my case also, my lord. And again subsequently, my lord, MFA 24/2016, page number 26. Honorable Justice Sanjay Kumar Medhi has also delivered this judgment, my lord. based on the decision passed by the full bench in writ appeal number 333/2010. Lordship, I have already marked it, my lord, the relevant paragraph. So this is my submission with regard to punitive charges on account of overloading of the court. Now, my lord, the entire issue they based on dealt by the Honorable RCT based on the admission as well as the law, my lord, held by the Honorable Guwahati High Court, my lord. So now there is nothing survive in this appeal, my lord. So the same shall be liable to dismiss. My lord. This is my humble submission.
So for the Learned Counsel for the respondent submitted that as per Rule 10 of the RCT claim table and procedure rule, an application in respect of the claim of refund of fare and freight referred to clause B and subsection 1 of section 13 of the Act may be filed before bench having territorial jurisdiction about the place at which such fare or freight was paid of the place where the destination station lies. Now there is two places for collection of the freight. A Southeastern Railway collected freight on a distance. This is the 1,32,000 something, and the punitive charge more than 2 lakh. It is collected by the NF Railway. So far, wrong distance, freight collected on the wrong distance, amounting to rupees 1,32,355. It is collected by the Southeastern Railway. So as per Rule 10 of the claim table procedure rule, the freight was collected as Vishnupuram at forwarding station, booking station. So on that ground, the RCT Guwahati has no jurisdiction. Only since the penal charge is collected by the NF Railway on the basis of the women charge, then only RCT Guwahati can entertain the punitive charge, not the charge collected by the Southeastern Railway at Vishnupuram. So, as per this is the rule, where the freight was collected or paid by the either consignor or whoever may be, the collecting freight was paid of that place. So, RCT Guwahati has no jurisdiction to entertain this claim which is collected by the Southeastern Railway over wrong distance. So, sir, my lord, now the Learned Counsel of the respondents raising the issue of the show cause notice is to be issued, which was already admitted in the writ appeal number 33 of 2010. This judgment of the full bench of this honorable court is under challenge before the Supreme Court, whether reasonable opportunity is required to be given or not. It is under Supreme Court. It is pending before the Supreme Court, my lord. On the basis of the pendency of the Supreme Court, the honorable court already estate the proceeding in MFA number 62 of 2013, MFA 59 of 2013, adjourn the matter till the decision of the Supreme Court, MFA 62 of 2013, MFA 59 of 2016. This is pending before the Supreme Court in SLPC number 008024 of 2018. So, though now it is no decision has been came out from the Supreme Court, in MFA 24 of 2016, this honorable court passed this order on the basis of decision of the full bench. Since it is not decided yet, no stay was granted by the Supreme Court till this date. So, since no order has been passed by the Supreme Court in this matter, the honorable court is bound to rely on the decision of this full bench decision. So, moreover, this show cause notice issue to be show cause notice, the issue is not framed in this case. Now, since the issue is not framed, RCT cannot take this point, and this point they cannot take any view of the matter. Without issuing a notice, without framing a notice, matter cannot be entertained. So, this issue from the judgment is completely clear, crystal clear, that whether show cause notice is required to be issued before payment of the consignment. This issue to be there. Then I can challenge the no issue was there and no reasonable opportunity was granted is violation of the principle of natural justice. I relied on the decision of the full bench of the Honorable Court passing detail number 333 of 2010. Since the issue is not there, I cannot raise this question. Now the question only arises, if under section 79, if there is no provision to revoke the consignment, they paid the penalty charges on protest. Then if there is no provision for revocation of the consignment at the time of delivery of the consignment under section 79, RCT itself in my judgment held that under section 79, railway party can request the railway administration to revoke the consignment. I am not satisfied. I have to pay the penalty charges, so I am not satisfied. It is owner risk or railway risk, whatever it may be. I am not satisfied. Though there is no, he has the right to claim the revocation of consignment. But if, yes,
after owner's risk.
if there is no the conditions, I have no right to request to revoke the consignment under section 79, then I am compelled to give the penalty charges as demanded by the railway. If I have to prove there is no overcharge, then I have to show burden of proof lies on the claimant, applicant under section 110 of the Railway Act. Burden lies on the claimant that if there is no overweight, it is railway collecting wrongly. So burden of lies. My lord, in this case, whatever judgments are cited, my lord, I have no Xerox copy. So I have to obtain the Xerox copy from this judgment, my sir,
Lordship, I would like to clarify one thing, Madam. Here, the senior counsel just now submitted that Rule 10 provides that destination station and the freight payment, where the freight payment was made, my lord. Here, two places are there. So, for distance, my lord, we have to approach South Central Railway, and for overloading, we have to approach NF Railway. This will lead to multiplicity of the suit. So, my lord, in order to prevent this, we filed a single claim application. Since the legislature provide us to file this application before the destination station, as destination station is also we can file there, my lord. So here we made both the parties. Not that we made only NF Railway and we did not give opportunity to the South Eastern Railway, my lord, South Central Railway. We made both them as a party, my lord. So they have the opportunity to defend their case before the tribunal. And accordingly, the learned tribunal has passed this judgment, my lord. So this is my submission with regard to Rule 10. And so far as, my lord, this SLP is concerned, my lord. So in page 28, paragraph 7, in MFA 24/2016, there is no stay order in that SLP, my lord. And based on that, the Honorable Justice S.K. Mehdi passed this order that they have given ample opportunity to the railways to secure the order of stay in that SLP. But they have failed to do so, my lord. They even now, my lord, they do not have any stay order, my lord. So this is my submission with regard to the SLP pending before the Honorable Apex Court, my lord. And so far as, my lord, excess weight that was detected at Adra, my lord, till date they did not did not deliver any excess goods to us, my lord. There is no excess good. If there is any excess good, then they have to give us the details of the excess good, which they have delivered to us, my lord. There is no such record available in the file, my lord, that they have delivered us any excess material, my lord. So this is my submission with regard to these three aspects, my lord. Otherwise, my lord, the judgment of the Honorable Full Bench is applicable in this case, my lord. It's squarely covered, my lord.
Well, for item 8, Mr. they already come to the court final. Let him submit. Item number 8. Yes.
We are responding that
Same, 8 and 7 is same matter, Lord. It is punitive charge under section 73, 78 and 79 of the usual way. 8.
Lordship, I am for the respondent 7 and
7.
7 and 8.
7 and 8 is
No, just not.
Wait.
Here we go, 5.
No.
5.
In 5, the respondent submitted. They replied in 7 and 8, she is not here. She is not in this case. So already 7, I said the item number 5 and 7 is the similar matter. And 8 also similar.
similar matter. 5, 7 and 8 is similar matter. But 7
Yes.
and 8 respondent is
We are
my
newly
learned
engaged,
friend.
Your Honor, and my name is also not reflected in the cause.
In 7 and 8.
Yes, Lord.
Goel.
Go ahead.
But Goel
Well,
is there.
yes, but Khandelia is engaged.
Already we argued.
तुम्ही नाही नक्की मनीषा तरी नाही.
Yes.
But bring 6, 7 and 8.
6, matter may be taken after 3 weeks, Lord.
No, not today.
Your name is reflected in 6.
Yes.
But if 6 with what any comfort with
I am for item number 7.
no,
No,
6,
6.
6 myself. Final.
आपल्यासाठी.
In 6, item number 6 is my case. Final. Item number 6.
6 you also there. 6 in 6.
Yes. 5, 7, 8, the same matter on the ground of the collection of the punitive charge. This is the shortage of the consignment.
6.
So 6 you are there.
Yes, Lord.
6 also there.
6 your name has been already reflected.
Yes, Lord.
Now in 7 and 8 was reading from Mr. A. Goel, name of Mr. A. Goel is reflected.
Yes. I am for G. Khandelia, Lord. His name is not reflected in 7 and 8.
You are appearing for G. Khandil.
Yes, Lord.
Now they have after my of that day. They have already completed 7, 5 and 7. 7
Yes.
and 8 are also there. But
Same man.
when he is not ready or
Lordship may be taken after 3 weeks, after 21st of May, any day after 21st.
6, 7, 8.
Yes.
see, these are all 11, 12 matters in fact.
Yes, Lordship, I understand that. Within
Maybe
this month
this
only
day
we will
they are-
complete hearing.
Will it be convenient for you to come with 1st of May?
Any day after 21st of May.
Any day after 21st?
Yes, Lord.
After 21st.
After May. Tuesday. 21st of May.
21st of
After 21st.
After 21st. No,
Any day.
22.
23rd. 22nd, no. 20, no, Wednesday. 29. 23rd, Thursday. Yes.
No, I say it is, I think, holiday.
Holiday maybe.
Yes.
24th, 25th. 28. 28.
28. Next. Your picture?
R. Paul.
You put 6, 7, 8.
Yes, 6, 7, and 8.
It's 7. You are there. No?
Yes, Lord.
7. You Chakravarti.
No,
You are
yes, 7.
7.
6, 7.
8.
I am there.
8 is me.
You are
Yes.
6. M. 7. Mr. BKD.
Well,
Them. 40.
6, 7, 8.
All three
Six
met.
is also 6.
Yes,
Who is
yes.
it?
I'm for the respondent.
Oh, it's 6 also.
Yes, yes.
6 also.
In 6, you also there.
Yes,
6 second. 6, 7.
I mean 6 and 7.
Yes, you are 6 and
I mean 8.
It's 8.
8.
Now see, as per their competence, by 31st,
Highly up.
it was the 11, 12. The method of for you. Number 5, but
Yes.
Obliged.
Obliged to Hmm?
May I please announce password for the time being, Mr. Gaynard will appear in this matter.
Let me start, my lord. Let me start.
you are for the whom? He is for the apple. You are for
Yes.
the respondent.
Respondent matter.
So who is the Mr.
Gaynard, listening counter, pick up the phone.
And they come
Because it's a very
PWD.
Yes, madam.
Okay.
Facing on legs, madam, still in port number 1.
Can he start?
let
I
me
have
start.
no idea.
No idea. Different. So
Better
he is for the appellant.
Yeah.
Your it's a not for the respondent or can he come? Question is that if he starts, you have any problem.
It will be better if he is present, madam.
Then, my lord, it may be taken at 2 8.
2-1 matter has already been fixed.
Oh,
So maybe some problem. I don't know if I can accommodate them if it is the matter because otherwise that's not matter.
may I conclude my part? It is a very small matter. Let them reply on some other day.
In your presence,
Yes.
okay.
Here, my lord, this is an appeal by the plaintiff. Appeal by the plaintiff against the 3 issues.
Appearance is the plaintiff.
Out of 6 issues, 3 issues were decided in favor of the plaintiff and 3 issues were decided in negative. So against that I preferred the appeal. And those 3 issues were 3, 5 and 6. My lord, those issues are mentioned in the
3, 5,
3, 5 and 6.
7.
Here, my lord, those are mentioned in page 36 of the memo of appeal.
Yes.
Whether the plaintiff is entitled to claim the cost of bitumen amounting to rupees 8,08,000 with interest of rupees 1,41,400 from the defendant till filing of the suit. And 5 is whether the plaintiff is entitled to claim the escalation compensation of rupees 39,900, 91,500 from the defendant. And 6 is whether the plaintiff is entitled to future interest or any other relief against the defendant. Now, my lord, for the convenience of the court, I have made in very gist the synopsis of my argument. Page number, everything are mentioned therein. Here in reply of issue number 3, my lord will find plaint at page para 8, 10 and 14. My statement in para 10, 14. Plaint starts from page 7. Page 7 of the memo of appeal. And the relevant page is page 11. Here, para 8, I am reading that the plaint, other than the works of the carpeting by the bitumen up to certain length of the road, had completed the works of major item, including the restoration works. The plaintiff could not complete the work of carpeting because in the relevant point of time there was acute shortage of bitumen in the market, and the plaintiff had brought the said fact into the notice of the defendant number 2 by letter dated 22/6/2007 with a copy to the defendant number 3. The plaintiff could purchase 147 drums of bitumen from Hindustan Petroleum Corporation Limited at a cost of rupees 6,99,644. But because of the rainy season, the work of bitumen carpeting could not be done. As per the instruction of the defendant number 3, the plaintiff had deposited 147 numbers of bitumen on 28/7/2007 and on 30/7/2007 with the defendant number 5. The plaintiff had completed 85% of the allotted works, although the plaintiff was not given the payment for the works completed by the defendant as per the stipulation of the contract, even on repeated request made by the plaintiff. The plaintiff had to borrow money on request from various financial institutions to meet his financial need to purchase the work, to complete the works with the extended period of time. Then another para is para 10, page 12, para 10. Under such circumstances, the plaintiff had no way out than to express his inability to perform the rest of the work by letter dated 1/10/2007 to the defendant number 3 and requested the defendant to finalize the work up to the stage within the extended period. The plaintiff also, by the said letter, sought for release of all outstanding dues, including the final payment, as well as the return of the deposit of 147 number of bitumen stored with due defendant number 5. The defendant number 3, on receipt of the said letter, asked the plaintiff to remain present on 20/11/2007 at 10 a.m. on the site of the measurement by issuing letter under memo number so-and-so dated 5/11/2007 with copies to the Assistant Executive Engineer PWD Helakandi, NEC Subdivision, and the defendant number 5 information and also for submission of the bill immediately. Then para 14. It is with regard to the bitumen. Para 14 is page 14. That it may further be pertinent to state here that stock of 147 drums of bitumen were kept with the defendant number 5 under the instruction of defendant number 6, who was holding the office of the executive engineer at the relevant point of time, and the value of the said stock of bitumen was 8,08,000. The plaintiff demanded back the stock of bitumen from the defendant number 1 by letter dated 3/3/2008 under registered post for use of the bitumen for PMGSY work under the Nagaon Rural Development Division, but the same were not returned back to the plaintiff. The plaintiff had to suffer for such act of the defendant as the plaintiff could not complete the said work. The plaintiff could come to know that the said bitumen were used by the defendant for some other purpose. The defendant are liable to make payment of the value of the bitumen with interest thereon, which comes to rupees 1,41,400 from 1/8/2007 to 15/4/2009 at the rate of 12% per annum to the plaintiff. So this is my case so far the bitumen is concerned. Now let us see their reply in written statement. The written statement, your lordship, will find at page 19. And para 10 is relevant. Para 10 and 15. Here para 10, the defendant's reply is that as regards the statement made in para 8 of the plaint, the answering defendant do not admit whatever is not borne by the record, and the plaintiff is to put strictest proof thereof. This is the simple reply. However, this answering defendant states that no official records are available about storage of bitumen at PWD godown. As the plaintiff is the owner of the bitumen, hence the question does not arise for storage of bitumen at PWD godown. Then another statement, your lordship will find at page 22, para 15. Para 15. As regards the statement made in para 13 of the plaint, the answering defendant states that there is no official record available of the then executive engineer regarding the written instruction of deposit of 147 drums of bitumen with the defendant number 5. As the plaintiff is the owner of the bitumen, hence the question does not arise for storage of bitumen. Hence the question does not. However, the plaintiff is to prove the statement made in the plaint in the paragraph by producing the records, if any. So this is their stand so far the defendant are concerned. Now let us see whether the plaintiff could prove it or not. In the lordship will find the evidence portion of the plaintiff. It is in the record. The examination in chief of Jayaprakash Bedia, PW1 on affidavit. PW1.
Order help.
Yes. PW1. We will find it out.
Either yes. Examination PW1.
Of PW1. Here the relevant paras are, I have already mentioned in my synopsis, para 14, 15, 16, 17, 24, 25 and 26. Here I have proved the purchase of bitumen as well as the storage of bitumen with the defendant number 5. and they have put their signature also. First of all, I am reading para 14 of my in chief at page 4. I had completed the work of major item, including the restoration work, other than the work of carpeting by bitumen up to the certain length of road. I could not complete the work of carpeting because at the relevant point of time, there was acute shortage of bitumen in the market. I have brought the said fact to the notice of the defendant number 2 by letter dated 22/6/2007 with the copy to the defendant number 3. I could purchase 147 drums of bitumen from Hindustan Petroleum Limited at a cost of rupees 6,99,644. But because of the rainy season, the works of bitumen carpeting could not be done. Then in 15, these are the statements which are from the plaintiff also. I will not repeat it. Only I will mention the exhibit.
Well, there was an order by the Honorable Court on 4/10/23, my lord. The petitioner was directed to provide a chart showing claim-wise statement made in the plain, evidence and the referable exhibits with a copy to us, my lord.
Yes.
But I'm told that the chart has been prepared. A copy has been given to me now, my lord. My lord, may I just kindly accommodate me for a day, my lord. Let me go through the chart and the LCR. The LCR is there. I'll just examine and come back.
Let me conclude by that time. Then they may reply.
I want to keep it at the part hard
Yes.
because the shape method is not this
True, ma'am. True.
It can be hard to how many in this week it said
I got the
next
chart
week it
now,
can be
Lord.
accomplished. 7th the holiday.
7th.
8, then 9. 9 is almost 14 and 16. Then 14 and
14. 14.
14.
Lordship. In the meantime, just I'll go to the LCR and see on 14.
Each complete his part.
May remain as a partner, my lord. Then
Or on that day, Lord, you can hear the both the sides.
He has already prepared the chart wise.
yes,
Correct.
it's a very.
I have received the chart now, Lord. It isn't given to me now.
We will submit in
Just-
very short.
Yes.
We are not going details of the matter. On very short, the relevant point I am just pointing out.
It was the understanding on the last on that day. That was the understanding. I have got the chart now. Kindly, the Lordship is taking up on 14th, and I'll go through in the meantime.
That you want to complete this part.
Let me come.
Or
So it will be better, Lord, if Lordship takes up on 14th. Together both of. Let it be on 14th, Lord. We'll
today
by the time we'll see.
it may be accommodated.
Yes,
So that's why we are giving priority.
Correct. It's a 13.
14 may be accommodated.
Yes. Then it remains as a partner, my lord.
Part third, if I'm ready to hear a matter, is a part third also. But if suppose my bench is not there in 14,
Yes.
then what will be the consequence and again will remain as a part third. So let it be on the reminder.
Yes.
We'll
It
definitely
can be hard.
Lodge.
So that's why the part third if
May not be.
so we'll fix it on 14.
My lord.
So we have chart with us.
Yes, sir. I have got the just now. I have got. I have.
Your devotee party that जब आप मेरे डॉक्टर that devotee party that getting
Correct. True. I'm on that one. Hello.
My lord, I have already submitted my letter.
In this matter, Your Lordship, in one IA was filed. This Honorable Court, on by order dated, just a minute.
I in I
Yes.
8/2/20.
This Honorable 8/2/2024. This Honorable Court, Your Lordship, in the MAC Appeal 365, 2018, directed that the ICICI Lombard should be made a party in this matter. Lordship has got the order. 8/2/2024 order.
I number
No,
No,
this
no,
is
in
the
the
main
appeal.
case.
Oh, in
Main
appeal.
case 365 2018.
Order dated.
Order dated 8/2/2024. So here Your Lordship directed the
ICICI Lombard.
yes. So we have filed the application for implement of ICICI Lombard by the IA. That's IA is there.
I don't think that I checked. I is
Not there.
no.
Your I number is 11635.
IA number to no.
So it should be on 2024, I think. But when I that's that is 1635 of 2021.
No, that is old lordship.
That is old.
I checked the record that I has not come.
Oh.
So again, you can check, no problem. I checked.
No, we are checking.
It has not.
It has not come. When you have filed?
It was filed Your Lordship sometime back on
23
to
February.
February.
23rd of February.
Oh. That's the signature on my copy. They
Even
charged us
our
about-
copy is there. No, why it has not? Lordship may fix the matter some other day. Let us verify. If some defect is there, that because without since there is a court order, without impleading, we cannot proceed with the matter. Let us decide. But
That's fine. Or number. Network.
তুমি আজি খবৰ কৰিবা নাই
Careful this that part of road. After one week.
Lord.
So in that case, I think have any.
No, lordship. Because the matter was heard at length, and then this was when I pointed out that there are two policies. So then the court ordered.
But in the added trial court below, so actually it was not the doctor.
No. But in the LCR itself, there are two policies, lordship. That is our contention. So
Policies were there, but they were not the party. In that.
no.
After one. Okay, we'll make an effort.
Lord, even I will also try to find.
File on 23rd of February.
We'll also try to provide this.
Maybe some defect.
Yeah, maybe. We'll then correct it and much of
It is Lordship. It is an appeal against the judgment passed by the learned Railway Claims Tribunal, Guwahati Bench, Guwahati, Lordship. By order dated 22/5/2019, the claim application was dismissed, Lordship. Claim petition was dismissed only on the ground that the deceased was not a bona fide passenger as held by the learned tribunal, and this was not an untoward incident. Lordship, may I go through the judgment? Read out the judgment. Date of accident mentioned 18/12/2014. This is
You have annexed the judgment copy.
Lordship.
You have annexed here.
Lordship at page 8.
Page?
8.
Yes.
11 portion starts from page 11, my lord, paragraph.
Okay.
Earlier page,
I'm reading out. Make skip that part. Documents filed with the applicant. In support of the claim, the applicants have filed certified copy journey ticket A1, certified copy seizure list A2, certified copy of dead body warning A3, certified copy of inquest report A4, certified copy of final report A5, certified copy of postmortem report A6, certified copy of identification report A7, certified copy of dependency certificate A8, ID proof of applicant A9, ID proof of deceased A10. On the other hand, the respondent has filed photocopy of DRM report, the next along with other relevant documents, matter exhibit R1. Issues pen. Whether deceased was a bona fide passenger, whether the victim died in an untoward incident, whether the applicant is entitled to for compensation, if so, to what sum, relief and cost. Issuers findings for the judgment. Issue number 1 and 2. These issues are taken up together for discussion and decision for the sake of convenience. The claim has been filed by the parents on death of their deceased son, late Fakhruddin Ali. As per the claim, application deceased was coming from NJP to Guwahati by up Kanchanjunga Express, and he accidentally fell down from running tank between Falakata and Gumanihat railway station. The journey ticket has been produced to establish the train journey. As per memo issued by the station superintendent Falakata, the body of the deceased was found near the track at about 11:40 hours on 19/12/2014. The nature of injuries are left knee, thumb in cut condition, left hand broken, one deep injury on hip, and above portion from the eye skull completely damaged. The postmortem report is not very legible, and the date is shown due to effect of injuries mentioned above. There are almost 6 injuries on his body. The body was also identified. In support of the claim, the claimant applicant appeared before the court and during cross-examination stated that his son, deceased, had called his second son that he is coming back from home after giving his interview by up Kanchanjunga Express train. He, however, came to know from a person of his village that his son met with an accident. The body was cremated at Silchar, which is the place of residence indicated in the claim application. In their defense, the respondent, through their DRM's report, has stated that the body of the deceased was found 7 feet away from the railway track with head injury and both the legs and hands were broken condition. Initially, the father of the deceased suspected that his son was murdered and filed an FIR under section 379/20 302 IPC, which ended up in a closure merely on account of mistake of facts. Later on, the applicant withdrew his complaint of his son's assault and pleaded that GRPS's final report of his son's death on account of his falling down may be considered as final. There are a number of discrepancies in this case, especially in aspect of authenticity of the ticket as well as victim's journey by 25256 Kanchanjunga Express. As per the claim application, he started journey from NJP on 18/12/2014 at about 18:30 hours. This said train crossed the place of occurrence at Amrabari, Falagata at 12:50 hours in early morning of 13/12/2014. However, the first information of the body lying on the track was only at 11:55 hours on 13/12/2014. That portion where from the learned tribunal got, it is not understandable. This is a main line section where numbers of trains are moving in each direction, and it is not possible for the body remaining undetected for such a long period of time. There is no mention of the journey ticket at the time of initial discovery of the body and during inquest. Inquest report is completely, this is there, and in their DRM report also, that the journey ticket was recovered from the possession of the deceased. It is there. When the identification was done on the basis of the identity card found near his body. The journey ticket issued on 18/12/2014 and the train mentioned started from NJP at 18:40 hours, and it did create a doubt whether journey happened by Kanchanjunga Express or not, and how he was found near the place of occurrence, away from the track in an injured condition. The injuries shown appear to be assault injuries with both his legs and hand found in broken condition, which may not happen in a falling down case. It appears that he was assaulted and his body damned near the track. All are imaginary, Lordship. The GRP has also failed to investigate any different angle. The GRP has also failed to investigate any different angle of his death or his death. The father initially suspected it to be criminal case suspecting murder attempt of his son. He later on withdrew by stating it was mistake of facts. The GRPS was unable to give any concrete evidence of his falling down. How his body was not discovered after 15 hours after his alleged fall. In the claim application, the journey by Kanchanjunga Express itself is a clear doubt. There is no other document to confirm his train journey as well as his accidental fall. The journey ticket timings of the train at place of occurrence and discovery of dead body and injuries all created big doubt about it being an untoward incident case. Thus, based on direct and corroborative evidence, the case of falling down cannot be proved. The applicant has thus miserably failed to prove his case, and as such, issue number 1 and 2 are decided against the applicant. Since issue number 1 and 2 are not proved, therefore the issue numbers 1 and 2 are decided against the applicant. Hence, issue number 3 and 4 are also decided against the applicant. It is ordered accordingly. The net result of discussion of the case as above is that the present OA is found to be devoid of merits. Therefore, the same is hereby dismissed and disposed of accordingly with no orders as to cause. Rest is directed to sensible sources. Now I'm reading out the evidence of AW1, the father of the deceased. I, Samad Mia, so and so, so and so. Number one, I am the applicant of the above noted case and victim is my son. And as such, I am well conversant with the facts and circumstances of the case. That on 18/12/2014, in the evening, my son, namely Fakhruddin Ali, was traveling from NGP railway station to Guwahati railway station with a valid railway journey ticket by up Kanchenjunga Express train. On the next day, that is 19/12/2014, in the evening, one local police person came from Ghungur outpost at my residence, Ghunguri at Silchar, and informed us that my son met with railway accident at near Falakata railway station, West Bengal, while he was traveling from NJP to Guwahati railway station by up Kanchenjunga Express train. Accordingly, on the next day, that is 20/12/2014, I sent my brother along with my son, and on 21/12/2014, they had reached there and identified and received the dead body. It is true that my son died due to railway accident while he was traveling from NGP to Guwahati railway station by up Kanchenjunga Express train with valid railway journey ticket. 5. That after death of my son, I along with my wife, namely Maharun Nes Begum, aged about 61 years. 3 son, namely Safar Uddin Ali, aged about so-and-so, Sabir Ahmed, so-and-so, and Sani Ahmed are dependents of my deceased son. I have collected certified copies of relevant documents in connection with the accident of my father from the concerned GRP and hereby submit those documents before the Honorable Tribunal as exhibit. Exhibit documents are there. Exhibit A1, Railway Journey Ticket, Lordship, at page 3. New Jalpaiguri. It is mentioned here, the ticket number is there, the journey from New Jalpaiguri to Guwahati. Date 18/12/2014. Ticket number 445. Ticket number is there, Lordship. Next, exhibit A2, Caesar list. In that Caesar list also, the railway journey ticket number has been mentioned. 44 in the below, Lordship. Nature of articles. G 44992001. Lordship got it? Dated 18/12/14 from NGP to Guwahati. And next, the exhibit 3, dead body challan. 4 is inquest report, Lordship. Translate copy is there, Lordship. Married it at page 7. On 1912.
Inquest was there. Inquest was done.
During the inquest, railway journey ticket was recovered. It is mentioned. at fourth paragraph, last but one line. Railway journey ticket has been found from the pocket of the deceased by ticket number so and so, so and so. Exhibit 5 is the final report. No? 5 final report. Exhibit 6 postmortem report. Exhibit 7 is of 11. And exhibit 8 next of pin certificate. And others are not so relevant for argument purpose. Now, Lordship can see the cross examination of AW1. On 18/12/2014, my son, late Fakhruddin Ali, was traveling from New Jalpaiguri to Guwahati railway station. On the same day at around 6 p.m., he called my son and informed that he was coming back to home after giving his interview by Kanchenjunga Express and he would reach home on 19/12/2014. On 19/12/2014 at around 9:30 p.m., I came to know from a person from my village that the police from Ghungur outpost informed the said person that my son, late Fakhruddin Ali, got a train accident. After knowing about the incident, I was in a shock. As such, my younger brother, along with my 3 more persons, went to Post Bihar TRP for identification of the dead body. Later on, after the postmortem, the dead body was handed over to us, and we brought the dead body at Silchar for cremation. In the entire incident, I am not the eyewitness. Here, no question of what was put as regards the railway journey ticket in cross. And falling from train, running train, no cross is there. Now coming to the DRM report, last you can see the DRM report main. The Nani Tribunal has not at all considered the DRM report. Misinterpreted the same, in fact. DRM report is there in the report. DRM report, Lordship.
It's dated 3/11/2016.
This is marked from
Tell us the page number.
page number 101.
101.
Starts. Pagination is reverse order, Lordship. 101, 199.
It's 10.
In X, Lordship. 100. Page. Very Lordship. In exercise of power conferred under Rule 7 of Railway Passengers Manner of Investigation of Untoward Incidents Rule 2003 as amended in 2007, IPF New Coach Bihar inquired into the subject case and submitted report along with its relevant documents. Inquiry report reveals that on 19/12/2014, at about 11:55 on receipt of memo placed at page 15 from SSFLK Falakata, Station Superintendent, SS Falakata, that one male person aged about 23 years named Fakaruddin Ali lying near the track at kilometer 94/1-2 in between Falakata and GUZ, Gumanihat, Falakata to Gumanihat, and seems to be dead as reported by JEPOA Falakata over phone. RPF officer and staff attended the spot and found one dead body of a male person lying north side about 7 feet away from railway track at kilometer 94/1-2 in between Falakata and Gumanihat, having head injury, both legs and hand broken and banned condition. ASI, GRP, and CB. Also attended the spot and conducted inquest of dead body, during which second class journey ticket number so and so from NGP to Guwahati and one identity card were recovered. The deceased was identified as Fakaruddin Ali, male, 36 years, son of Samed Ali so and so so and so. After inquest, GRP and CB took the dead body under custody and sent the postmortem for postmortem and registered an UD case number so and so dated 19/12/2014. In postmortem report, doctor opined that cause of death was shock or hemorrhage due to effect of injuries mentioned in the postmortem report, which were antemortem in nature. GRP investigating officer, after completion of this investigation, submitted final report in UD case to concerned court. During inquiry by RPF officer, it came to light that father of the deceased had lost affair at Silchar police station so and so, Beijing, on which a crime case number so and so was registered and transferred to OC, GRP, and CB. NCB means New Coast Bihar. OC, GRP, Government Railway Police, on the point of jurisdiction. Accordingly, OC, GRP, and CB registered the case in crime number so and so under section 379/302 IPC and took up investigation. On completion of investigation, final report has been submitted to the concerned court as a mistake of fact. In fact, earlier it was informed by some other persons. The father of this came to know from other source that his son was murdered after taking his belongings. His all luggage and all belongings were taken away and thereafter murdered. It was the impression earlier, but thereafter he came to know that he fell down from the running tent and subsequently died. You recorded the statement of Sudipta Vishwas, JEPOA FLK Falakata statement. So he stated that on 19/12/2014, while proceeding towards Gok Sangada for routine checking of railway track at about 10:45 hours, noticed one dead body of the male person having head injury lying outside the track at kilometer so in between Falakata and Gumanihat. He detected one identity card near the dead body, and on appraisal of which he came to know name of the deceased as Fakhruddin Ali, and accordingly he informed the matter to SS Falakata. R.P. Mandal, in his statement, stated that on 19/12/14 he was on duty from 6 hours to 14 hours. At about 10:45 hours, he received an information regarding the lying of one male person seems to be dead at kilometer so in between Falakata and Gumonihat. Accordingly, he issued memo to all concerned. RPF staff SC.D. Chaudhary and CT B.K. Chaudhary, B.K. Ghosh posted at Falakata have been examined and their statements were recorded. Both of them stated that on 19/12/2014 at about 11:45 hours on receipt of information from SS Falakata, Station Superintendent Falakata, they had rushed to the spot and noticed one male person lying near the track at kilometer so between Falakata and Gumonihat.
And thereafter one FIR was there.
FIR was lost earlier.
It was ended on FIR.
Lost it. It was a mistake of fact, in fact. Lost it.
So they say that he
in fact,
from the state, he fell down from the
running train.
And that after that accident, he
Lost it.
Now, why? What your subject that why it is not a attempt to murder or rather it was a
lost it.
Anyway,
It is in fact
ticket was recovered.
Railway ticket was recovered from the possession of the deceased, and one identity card also recovered. And in the identity
regarding the identity, there is
no dispute. Ticket was recovered from the possession of the deceased. As per the claim, the deceased was travelling by up Kanchenjunga 15657 up and fell down from the train in section Falakata Gumonihat station. Hence, the EO perused the main train movement register of Falakata station, which reveals that the said train had arrived at Falakata station on 20:55 hours and left 20:57 hours of 18/12/2014, and there was no report or memo by train guard or LP regarding falling down from any passenger from the train. As regards verification of journey ticket recovered during inquest, CCC Falakata issued certificate dated 31/10/2016, page 17. After completion of inquiry, analysis of all documents, inquiry officer concluded as under. The UD case and crime registered under section 379/302 IPC by GRP and CB in connection with the same incident and ended in closure submitting final report as well as mistake of fact. No any foul play has been found to be recorded during investigation. Number 2, no any wrongful act, neglect or default on the part of the railway administration came to light during the inquiry, either by inquiry officer of RPF or investigating officer of GRP. In conclusion, under these above circumstances, it is established that the deceased had fallen down from the running train in the section due to his own carelessness and negligent act for which he himself was responsible. It is the conclusion of the respondent authority, conclusion of DRM report, that the deceased had died by falling down from running train. Once again, I am reading it. Under the above circumstances, it is established. That means they admitted that the deceased died by falling down from a running train. But the Raleigh Tribunal came to the adverse finding, has not considered at all the GRM report. The next page, 98. What was? So railway journey ticket is there, Lordship, recovered from the possession of the deceased. And the railway authority admitted that the deceased had died by falling down from running train. So it is established that the deceased was a bona fide passenger of the train and died due to untoward incident. So the findings of the Raleigh Tribunal is perverse, in fact, without considering at all the DRM report submitted by the other side. Lordship, once again, kindly see the memo bill, page 12, Lordship. Paragraph 3. Lordship, got it? Memo appeal, paragraph, page 12, paragraph 3. There are a number of discrepancies in this case, especially in respect of authenticity. Para 3, Lordship.
Yes, sir, you have already said.
There are a number of discrepancies in the case, especially in respect of authenticity of the ticket as well as victim's journey. By 25256, Kanchanjunga Express. Well, I have not mentioned any number. In fact, the number is wrongly quoted here. Where from the Raleigh Tribunal got it, I don't know. As per the claim application, he started his journey from NGP on 18/12/2014 and at about 8:30 hours. At about 8:30 hours, the said train crossed the place of occurrence at Amarabari, Falagata on 12:50 hours in early morning of 13/12/14. The deceased started journey on 18/12/2014. Where from the Raleigh Tribunal got it?
Because the ticket was issued on 18.
And how about the first information of the dead body lying on the track was only 11:55 hours on 13/12/14, after almost 15 hours. And now this main instructions also, next page, Lordship. There is no mention of journey ticket at the time of initial discovery of the dead body and during inquest. So it is, the report also shows that during inquest, the railway journey ticket was recovered from the possession of the deceased. So, falling down from the train, it has been admitted by the other side, and railway journey ticket was recovered from the possession of the deceased. So, the deceased was traveling with a valid journey ticket. He was a bona fide passenger, and he fell down from the running train, accidentally fell down from the running train. This is an untoward incident as per provision of section 123 of the Railway Act. So, Raleigh Tribunal has come to the findings without considering at all the DRM report submitted by the other side. Let him argue and then I will reply.
May it please your lordship. Lordship, I'd beg to mention item number 15, lordship. My senior is out of station, so kindly the matter may be fixed in the next week, on 9th of May.
I'm for the other side.
Yes, lordship. Item number 15. Yes, 9th of May. Obliged, lordship.
On the prayer of appellant lordship, please.
I'm for the appellant.
My lordship, item number 16, I beg to mention. My lordship, may be pleased to adjourn the case for today.
I'm the appellant, she is the respondent.
My senior is on leg in court number 13. Adjournment. Court number 13. R. Goswami.
Highly obliged, lordship.
Right, please, your lordship. Probably my colleague has concluded this argument. Now it's my turn to reply.
Yes.
Lord, he has already read out the judgment, my lord. Probably there are certain incorrect facts recorded in the judgment, my lord. I will not be harping on those, my lord. I will be basing my arguments only on the admitted facts. Admittedly, the journey ticket was recovered from the possession of the deceased, my lord. I am not disputing that. I will not be disputing. Now, my submission would be, my lord, this is settled position of law, and probably my colleague would also not dispute that in order to sustain a claim for compensation in a matter pertaining to untoward incident, two things have to be proved, my lord. Number one, that the victim was a bona fide passenger. Bona fide passenger means a person who was traveling with a valid railway journey ticket. Number two, that the deceased was a victim of untoward incident. Untoward incident has been defined as, my lord, accidental falling of a passenger from a train carrying passenger. These two things have to be proved, my lord. Now, before I start making my submissions, my lord, I would like to place before your lordship one relevant provision of the Railway Act, my lord, section 124. Railway Act, section 124. Just come. Yes, section 124. This is the relevant provisions, my lord. Relevant provision under which compensation is awarded. May I read out? Section 124A is relevant. Compensation on account of untoward incident. When in the course of working a railway, an untoward incident occurs, then whether or not there has been any wrongful act, neglect or default on the part of the railway administration, such as would entitle the passenger who has been injured or the dependent of a passenger who has been killed to maintain in action and recover damages in respect thereof, the railway administration shall, notwithstanding anything contained in any other law be liable to pay compensation to such extent as may be prescribed, and to that extent only, for loss occasioned by the death of or injury to a passenger as a result of such untoward incident. Proviso, this proviso I would be relying upon, my lord. Provided that no compensation shall be payable under this section by the railway administration if the passenger dies or suffers injury due to suicide or attempted suicide by him. Lordship may skip this. B is relevant for us. Self-inflicted injury. The others are not that relevant, my lord. This subsection B would be relevant for us, and how it would be relevant, I'll come to that later on, my lord. Now, Lordship had seen the judgment, my lord, and the nature of injuries sustained by the victim. His hands and legs were broken in a bent condition. His probably skull was also fractured, and certain parts of the upper limbs were also cut into pieces, my lord. Now, this kind of an injury, my lord, cannot be sustained by a person who had fallen down from a train. It can happen only when he is either knocked down by a running train or someone has criminally assaulted him. And this is probably precisely the reason why the father of the victim had lodged an FIR, claiming that his son was murdered. And in a case of this nature, my lord, the injuries sustained by the victim are of very much relevance, my lord. I have a judgment to that. I'll come to that aspect later on. Now, so far as the other thing is concerned, my lord, accidental falling down of the victim from the train, my lord, that aspect, that onus to prove that he had fallen down from the train lies on the appellant, my lord. The side claiming the compensation. That negative onus cannot be shifted on the railway. These aspects of the matter has been settled by Honorable Apex Court decision, my lord. And now I'll be placing that decision, my lord, before your lordship. In fact, entire submission should be based on 4 decisions, my lord. That would make my point clear. The number 1 judgment, my lord, that I would be relying on is, my lord, the decision rendered in the case of Kaliram Kaur. It is a judgment rendered by Honorable Justice S. Sham, my lord. Similar are the facts and circumstances in this case, my lord. In this case also, victim was a bona fide passenger. That was not disputed. She had a valid railway journey ticket. But the fact that she had fallen down from the running railway train, it could not be proved, my lord, and hence the compensation was denied. Now, lordship may directly come to paragraph 16 of the judgment, page 5 onwards, my lord. The earlier portion, those portions are not that relevant, my lord. I beg your lordship to skip those portions, my lord. Lordship may skip it to paragraph 16 onwards. May I read, my lord? Since the Learned Counsel for the Railways has not disputed the fact that the deceased was travelling from New Tinsukia to Simoliguri Junction on 28/12/2014 based on a valid journey ticket, the question as to whether the deceased was a bona fide passenger or not need not detain this court. The core question arising for consideration of this court in the present case, therefore, is as to whether the appellant claimant had succeeded in leading evidence to prima facie establish his claim that the deceased had died in an untoward incident as defined in Section 123C of the Act of 1989. Section 123A of the Railway Act 89 defines accident, which means an accident of the nature described in Section 124. Section 123C of the Act of 1989 defines an untoward incident, which reads as follows. Untoward accident means the commission of a terrorist. Lordship may skip all this, my lord. Number 2 is relevant. The accidental falling of any passenger from a train carrying passenger. This is relevant for us. As per Section 124A of the Act of 1989, the railways would be under an obligation to make payment of compensation on account of death or injury suffered by a passenger in an untoward incident, provided that no such compensation shall be payable by the railway administration if the passenger dies or suffers injury due to A. An attempt of suicide by him, B. Self-inflicted injury, 3. His own criminal act, D. Any act committed by him in a state of intoxication or insanity. Going by the scheme of the Act of 1989, it is clear that the railway administration would be under an obligation to pay compensation only if the death or injury had occurred to a bona fide passenger in an untoward incident within the meaning of Section 123C of the Act of 1989. Coming to the facts of the present case, the appellant has claimed that his deceased wife could not get down from the train at Simoluguru Junction due to heavy rush of passengers and later on accidentally fell down from the running train while trying to get down and was run over by the train. If the version of the claimant is found to be correct, then his case would fall under Section 123C, subsection 2 of the Act of 1989. But in this case, no one had witnessed the incident and there is no other evidence to establish the circumstances under which the wife of the claimant had died. Roshi may kindly note this particular line. Similar is the case out here, Mali. There is no evidence at all to substantiate the claim of the applicant that he had fallen down from a running train. There is no dispute in the case about the fact that the body of the victim was recovered from the railway track in the morning hours of 29/12/2014. A perusal of the post-mortem report goes to show that the death of the victim had occurred due to coma as a result of the injuries sustained. The post-mortem report further reveals that there is crush injury in the occipital part of the head involving soft tissues, bone and brain matter. On dissection, other internal organs were found healthy. It was opined by the doctor that the injuries were antemortem in nature. The post-mortem report, however, does not indicate that the body was dismembered in any manner. Therefore, from the nature of injuries reflected in the post-mortem report, it is apparent that the victim did not come under the wheels of the train but was knocked down by a running train. From the inquest report dated 29/12/2014, it is seen that the body of the victim was found lying in between two railway lines facing the earth, and brain matters and pieces of the skulls were found lying scattered in the railway track. If the victim had actually fallen down from a running train as claimed by the appellant, it is not clear as to how the body could have been found lying inside the two railway lines. It is highly improbable that a person accidentally falling down from a running train would come under the wheels of the same train. Likewise, after falling down from the running train, the victim could not have suffered the nature of injuries indicated in the post-mortem report. This is also relevant. The learned counsel for the appellant also could not give any satisfactory answer to the queries made by the court on the above points. It is the admitted position of fact that there is no eyewitness. This paragraph, my lord, assumes significance in our case. It is the admitted position of fact that there is no eyewitness to the incident. From the testimony of the claimant's witness AW1 Kaliram Kaur, that is the husband of the victim, it is found that he also did not have any personal knowledge as regards the death of his wife. As a matter of fact, the witness AW1 had deposed that he had come to know about the death of his wife from the daily newspaper Janambhumi, wherein it was reported that an unclaimed female body was lying at the police station at Simoluguri. It is surprising that the appellant did not make any inquiry about the whereabouts of his wife, even when she did not reach home several hours after the scheduled time of arrival of the train at Simoluguri. From a careful analysis of the materials available on record, it is evident that the story projected by the claimant regarding the accidental death of the victim is entirely speculative, nothing but guesswork, which is not supported by an iota of evidence. The materials on record raises more questions than giving answers to the queries as to the circumstances under which the victim had died. In the absence of any witness account, it is not known as to how the claimant could know that there was rush in the train and the victim fell down while trying to get down from the train. The said aspect of the matter assumes great significance since the claimant himself has claims to have learned about the death of his wife from the morning newspaper. Same is the situation out here, my lord. The claimant, who was the father of the victim, He had himself in his cross-examination stated that he was not an eyewitness to the incident. In fact, he had never gone to the place of accident, my lord. So his entire story was speculative. There is no evidence on record to show that the person had accidentally fallen down from a train. And this initial onus to prove that the victim who died in a railway accident, in an untoward incident, lies on the claimant side. That negative onus cannot be settled on the railways, my lord. That is what has been said by the Honorable Apex Court, my lord, in the case, my lord, by the title Reena Devi, my lord, which is referred to here in paragraph 24. In the case of Reena Devi Supra, the Honorable Supreme Court has held that initial burden to establish the plea of bona fide status of the passenger or the injury of the deceased in a claim for compensation would be upon the claimant. By taking note of the decisions of different courts on the aforesaid subject, the Honorable Supreme Court has interpreted the proviso to section 124A and held as follows. We thus hold that mere presence of a body on the railway premises will not be conclusive to hold that injured or deceased was a bona fide passenger for which claim for compensation could be maintained. However, mere absence of ticket with such injured or deceased will not negate the claim that he was a bona fide passenger. Initial burden will be on the claimant, which can be discharged by filing an affidavit of the relevant facts, and burden will then shift on the railways, and the issue can be decided on the facts shown or the attending circumstances. This will, however, be dealt with from case to case on the basis of facts found. A legal position in this regard will stand explained accordingly. That was a case where the wife of the victim had filed a petition claiming that her husband had died in an untoward incident when he fell down from the train due to rush of passenger and died on the spot. The railway had opposed the claim on the ground that the deceased was not a bona fide passenger but was wandering in the railway track since he was suffering from mental disorder. In the present case, save and except recovery of the body from the railway track, there is no other material for holding that the death of the victim had happened in an untoward incident. There is also no evidence to show that there was rush of passenger in the train in which the victim was traveling on the date of incident. Therefore, the circumstances under which the wife of the appellant had died is completely unknown. The case projected by the claimant is not only found to be unreliable, but even necessary materials to make out a prima facie case is missing. As such, in the absence of any cogent material to indicate the circumstance under which the incident had occurred, mere presence of a dead body in the railway track would not justify an inference that the victim had died in an untoward incident. In order to succeed in a claim for compensation in an untoward incident, the initial burden would always be upon the claimant to show that the death of the victim had resulted from an untoward incident, within the meaning of section 123C of the Act of 1989, which burden the appellant claimant had failed to discharge in this case. It is no doubt correct that there was no cogent material available on record permitting the learned claims tribunal to record a finding of fact that the victim had died due to her own carelessness and negligence, and to such extent the conclusion drawn by the learned tribunal cannot receive the approval of this court. But such erroneous conclusion of the learned tribunal alone would not be sufficient for this court to allow the claim petition by the appellant on merits. Paragraph 27. Lordship may skip. 28, the concluding paragraph. It is to be borne in mind that the compensation under section 124A of the Act of 1989 is a relief provided under statute, and therefore, unless the conditions prescribed by the statute is made, no direction for payment of compensation can be issued by the court. In the present case, as noted above, the claimant has failed to establish that the death of the victim had occurred in an untoward incident. As a matter of fact, there is no clarity as to the circumstances under which the victim had suffered death. As such, having regard to the facts and circumstances of the case, I am of the opinion that the learned tribunal has rightly dismissed the claim petition. Following this, my lord, two other decisions, I would only place the two other decisions have been rendered by this honorable court, my lord. I would just place the relevant paragraphs. the judgment rendered in the case of Rukmini Chauhan. Lordship may kindly take that. I'll just refer to two paragraphs only. Page 3, paragraph 11. This also refers to Reena Devi, my lord. Referring to the decision of the Honorable Supreme Court in the case of Union of India versus so-and-so, the learned counsel, Mr. Sharma, has submitted that the appellant has failed to discharge the initial burden of proof and therefore the learned tribunal has correctly rejected the claim application. I have bestowed my anxious consideration to the submission made by the learned counsel for both sides. At this stage, this section 123 is quoted, my lord. I'll skip that if your lordship permits. Come to paragraph 14. Under the provisions of section 124A of the Act of 1989, the railway is liable to pay compensation for an untoward incident. Accidental falling from a train is an untoward incident. Therefore, it must be proved first that the deceased was traveling in a train and he fell from a running train. This fact will be proved if a valid ticket is found. In the case on hand, no valid ticket is recovered. The death of a person caused by a train does not itself become an untoward incident for which the railways will be bound to pay compensation under the law. Paragraph 16 of the Reena Devi's judgment is quoted. We thus hold that mere presence of a body on the railway premises will not be conclusive to hold that the injured or deceased was a bona fide passenger for which claim for compensation can be maintained. However, mere absence of a ticket with such injured or deceased will not negate the claim that he was a bona fide passenger. Initial burden will be on the claimant which can be discharged by filing an affidavit of the relevant facts, and burden will then shift on the railways, and the issue can be decided on the facts shown or the attending circumstances. This will have to be dealt with from case to case on the basis of the facts found. The legal position in this regard will stand explained accordingly. In the present case, there is no doubt that the dead body was recovered in the railway tracks, but this fact per se does not prove that the deceased was traveling in the train and he died after falling from a running train. No valid railway journey ticket was discovered to have an opinion that the deceased was actually traveling in a train. Going by the principle laid down in Reena Devi, the appellant failed to discharge the initial burden, and in such a case, the burden of proof doesn't shift on the railway. The burden of proof to establish the plea of bona fide status of the passenger or the injury of the deceased because of an untoward incident in a claim for compensation is always upon the claimant. The court finds that the impugned judgment is a well-reasoned judgment. Even the identity of the dead body has not been proved. Ultimately, the matter was dismissed, my lord. Now, we may come to the third decision in the case of Union of India versus Lakhi Prabha Sonwal. It's a very recent decision, my lord, rendered on 2nd of February 2024. And this judgment has followed the earlier judgments, my lord. And I'll start from paragraph 21, my lord, page 7. From page 7, para 21. Earlier paragraphs, my lord, the facts of the case was narrated. So the relevant portion of the judgment, my lord, the ratio in the law that has been laid down can be called out from paragraph 21 on. May I read up? It is true that the definition of the word untoward incident in section 123(c)(2) of the Act is exhaustive. It can only be construed having regard to the further consideration that the scheme of the Act appears to be that the legislature has marketed the railway with the liability to pay compensation without reference to there being any need to prove wrongful act, neglect, or default on the part of the railway administration. The liability imposed on the railway can therefore be held to be not a tortious liability as understood in law. It is also true that the provisions should receive a liberal construction, but we cannot carry the matter to the point where if the facts as established to show that the incident cannot be brought under untoward incident. If there is accidental falling of any passenger from a train carrying passenger, it would be an untoward incident. In the instant case, admittedly, there was no eyewitness to the incident that anybody had seen the deceased falling down from the train in which he was allegedly traveling on the date of accident. It is also admitted that no journey ticket was found from the dead body of the deceased. Nobody had seen the deceased person had purchased any ticket for his journey from Dhemaji to North Lakhimpur. Two witnesses examined by the claimant were not present when the incident occurred. Same is the case out here, my lord. The only witness who examined himself was not an eyewitness. He had not even gone to the place of occurrence, my lord. Therefore, it is not proved that the deceased died due to falling from the train of the Intercity Express down so-and-so while he was travelling from Dhemaji to North Lakhimpur. The only fact is that the dead body was recovered near railway track in between so-and-so to so-and-so railway station. Except the recovery of the dead body near the railway track, there is nothing on record to show that the case of the deceased falls under the purview of Section 123(c)(2) of the Railway Act, that is untoward incident. In the case of, I'll skip this paragraph, my lord. These paragraphs are referring to certain judgments of the apex court, my lord. Now, based on the law laid down in those judgments, my lord, honorable court has come to its own conclusion. Question may come to paragraph 24 now. To claim compensation under section 123(c)(2) of the Act of 1989, the claimants have to satisfy two main ingredients. Number one, the accidental falling of any passenger from a train carrying passenger, and he must have purchased a valid ticket for travelling in the train carrying passenger, and the explanation to section 124A of the Railway Act 1989. In the case in hand, admittedly, it is not proved that the victim had purchased any ticket for his journey in the alleged train from Dhemaji to North Lakhimpur. In this case, I am not disputing the presence of the ticket, my lord. My submission would be that it is a case where the claimant side had failed to discharge their initial burden to prove the fact that the victim had fallen down from a train carrying passenger. In the case in hand, admittedly, it is not proved that the victim had purchased any ticket for his journey in the alleged train from Dhemaji to North Lakhimpur, and the accidental fall resulting in death of the victim is also not established. Thus, we hold that this is not a fit case for claiming compensation under section so-and-so, and the issues are answered in favor of the appellant. The legal position with respect to the untoward incident inside the railway station is well settled. Section 124A of the Railway Act is based on the principle of no-fault liability, and the compensation cannot be denied to the appellants on the ground that the deceased was negligent, and it is wholly irrelevant as to who was at fault. Section 123(c)(2) of the Railway Act defines untoward incident to include the accidental falling of any passenger from a train carrying passenger. The word passenger has been defined under Section 2, subsection 29 of the Railway Act of 1989 as a person travelling with a valid pass or ticket. The explanation to Section 124A clarifies that the word passenger includes a railway servant on duty and the person who had purchased a valid ticket for travelling in a train or platform ticket and becomes a victim of an untoward incident. As such, there are three categories of persons who are defined as passengers. Passenger, a passenger with a valid ticket to travel, a person who holds a railway pass to travel, and a person who holds a platform ticket. In each of the categories, so long as the person is in the railway premises or a train is taken as a passenger, his or her presence in the railway premises or a train is taken as authorized. However, it does not amount to become a victim of untoward incident. On reading of the definition as aforesaid, still the word untoward incident would mean only that there must be an accidental falling of the passenger as aforesaid from a train carrying passenger. In the present case, the admitted position of the fact of the case is that the body of the deceased was recovered near the railway track. Nobody had seen the deceased falling from any train, and no valid ticket or railway pass or platform ticket was found from the dead body of the deceased. It is true that Section 123(c) of the Railway Act should receive liberal construction, but we cannot carry the matter to the point where if the facts as established would show that the incident cannot be brought under untoward incident, the law requires the accidental falling of a passenger from a train carrying passenger. Even then, this is not a case where a passenger was trying to board a train and he falls by way of an accidental fall from the train. In the facts of the case, even accepting all that has been stated by the respondent claimant, in spite of that, we cannot bring the case of the deceased as ill-fated passenger who fell down from the train. In the case in hand, as I have already stated, that the deceased was not having a valid ticket for traveling on the fateful day, it is also not proved that there was any accidental falling of the deceased from a train carrying passenger. No eyewitness was examined by the respondent claimant to prove that they had seen the deceased had purchased any ticket from his journey from so and so to so and so in the intercity express so and so, and he had accidentally fallen down from the same train in between so and so railway station. And under such backdrop, this court is of the opinion that this is not a fit case for compensation under section 120. These are the three decisions I am relying on to harp on the aspect that the claimant side had miserably failed to prove the fact that the victim had fallen down from a running train. That initial burden to prove the fact that it is an incident of untoward incident, that burden always lies on the claimant side, not on the railways. Once the initial burden is discharged, then the ownership on the railways. Now, in this case, my lord, as lordship has already gone through the record, my lord, the judgment and the other reports, my lord, there was no eyewitness to the incident. Even the witness who had examined himself in the case, my lord, it's his own version in cross-examination that he was not an eyewitness. He had not even gone to the place of occurrence. So, in my submission, there is no evidence at all in this case to prove that the person, the victim, had died in an untoward incident. Secondly, my learned friend had relied on the report of the DRM. My lord, that report, in the last paragraph, it probably mentioned that, my lord, I'm not sure of the page number in the LCR.
100.
The report dated
100.
3/11/2016. 3/11/2016. On top, my lord.
Yes, 100.
Yes.
11. Yes.
Yes. And this report, in the last paragraph, it says, under the above circumstances, it is established that the deceased had fallen down from the running train in the section due to his own carelessness, my lord. Lordship may kindly take note of this word, my lord. Carelessness and negligent act, for which he himself was responsible. And now, this recording of fact, my lord, by this report was based on the investigation report that was submitted before this authority by the inspector of the RPF, my lord. That report is dated 1/11/2016, my lord. I'm not sure about the page number in the LCR. It states on the top right hand corner, Office of the Inspector RPF NCB, New Coach Bihar. As your lordship got that. Report dated 1/11/2016. The date is mentioned in the top left hand corner, my lord.
You are on inquiry report.
The subject states details investigation report against claim case number so and so. The report just
101 report is there.
3/11/100.
3/11.
This report is based on the investigation report submitted by the inspector of RPF, my lord.
Well, it is 1/11.
My lord, can I have?
Other report is 1/11.
Yes, 1/11.
Page number? Because the 3/11 we think is there.
I'm not sure about the page number in the LCR. Can I?
100 is the report.
Nine.
98
Page number 98, Mel. 98. Probably 98.
98 পিছফালে থাকিব নাই
Also, got that, Mel?
Yes.
Now, Worship has seen the last paragraph of the report dated 3/11/2000.
Yes, it is observed that this is due to carelessness.
Carelessness and negligent act of the victim himself. Why this particular fact has been recorded? It is because of the last paragraph in the other report. This is the investigation report, page 3 of the report. If Lordship may kindly come to the last paragraph. So, paragraph starts with the words on going through the above documents as well as investigation report, it revealed that the victim so and so was traveling on the door as well as footboard of the coach, due to which incident took place, which is a negligence on the part of the victim. There is no fault of railway in the above case, hence in my opinion this is not fit for claim compensation. Hello. I am not approving this fact that he was traveling inside the train and because of this negligence he had fallen down. That is not my main argument, my lord. Even assuming that he was actually traveling inside the train, then his fall from the train was because of his own negligent and careless act, my lord. And this would come within the exception mentioned in section 124A of the Railways Act. That would amount to a self-inflicted injury. And on this aspect, I've got another judgment of truth. This has been explained, my lord. It is not my case that he was inside that. This
injury sustained by the victim was
relevant, my lord.
Because hand one mostly broken, one leg is also broken, one hand
So
also broken.
that is very much relevant because
Injury.
a person falling down from a train cannot suffer that kind of an injury, my lord. Either he has to be knocked down by a running train. In that case, my lord, if he has to be knocked down, then he was in front of the engine, my lord. That would clearly establish the fact that he was not inside the train and he had not fallen down. And other circumstance can be, my lord, he was brutally assaulted by someone. And that is precisely the reason why the father of the victim had filed the FIR initially. Subsequently, he changed his mind. Now, on the aspect of self-inflicted injury, my lord, I've got another. This is a case from some only, my lord. Here, the person was a bona fide passenger. He was a passenger. He was admittedly inside the train, my lord. He was admittedly inside the train. What he did was, my lord, he got down from the train from the wrong side and tried to cross over the railway track to reach the other platform. In the meantime, another train was coming from the other side and he was knocked down. And it was held to be an act of negligence, and compensation was denied, my lord. I would rely on paragraph 9, 10, 12, 13 and 14 of the judgment. Married. It is a pleaded case of the appellants in paragraph 6 of the claim petition, which is as follows: that on 24/4/2014, the deceased so and so got in the sleeping passenger train down from Guwahati railway station to Nalbari. While the said train reached at Ghagrapar railway station, the victim, namely so and so, slipped from the train at the Ghagrapar railway station due to sudden and heavy jerking on the of the said train and he was run over by so-and-so Rajdhani Express and thus sustained grievous head injury and other multiple injuries to his person. As per the evidence on affidavit of AW1, the Sifung train had reached Bhograpa railway station and the deceased entered the toilet, and after a few minutes he came out and was washing his hand and face in front of the basin, and due to sudden and heavy jerking, the deceased fell out of the running train at Bhograpa railway station and he was run over by the Rajdhani train. The said AW1 in a cross-examination has stated that the deceased was run over by Rajdhani Express at Bhograpa when the deceased got down from the Sifung passenger train. AW2 so-and-so also made a similar statement in his evidence on affidavit that due to heavy jerking, the deceased slipped from so-and-so at Bhograpa railway station, and on his information to the TT, the train was stopped. In his cross-examination, the AW2 has stated that he did not know the actual cause of death of his deceased father. AW3 so-and-so also stated that the deceased slipped from the running train at Bhograpa railway station due to sudden and heavy jerking of the offending train and he was run over by the Rajdhani Express. In his cross-examination, AW3 had stated that as the train was approaching the station, the victim fell down from the other side of the coach and not on the platform side at Bhograpa railway station. He also stated that the train stopped at so-and-so and there were many passengers who went to the spot and that he did not go to the spot but saw the victim's body lying. He did not see the victim's body cut into pieces but saw. Lordship may skip all this. Lordship may come to paragraph 12. The learned counsel for the respondent has vehemently submitted that as per the final report, the deceased have fallen down from the Sifung passenger train and was knocked down by Up Rajdhani Express at the time of crossing. He has submitted that if a train was given crossing, it is a standard operating procedure that the train would be standing at the platform while giving crossing to the Rajdhani Express. It is submitted that under such circumstances, there would be no sudden and heavy jerking towards the standing train, which would cause passenger to slip down onto another track where he could be hit by a running train. He submitted that the only way such an incident can happen is when a passenger gets down from the train at the wrong side, opposite the platform side, and was unauthorizedly trespassing on the other railway track, which was given clearance for the Rajdhani Express to cross over. In the light of such submission, the court is of the considered opinion that the evidence of AW2 and AW3 to the extent that the deceased had slipped from the train while the train was approaching Bhograpa railway station and he was run over by Rajdhani Express is not believable because if the Sifung Express was in motion, the Rajdhani Express would not have been given crossing. The evidence of all the three AWs cannot be believed to the extent that the deceased would slip out of the train with heavy jerking so as to fall on the second track and get run over by the train. Hence, there appears to be no infirmity in the finding recorded by the learned tribunal that the gap between two lines was big enough for any passenger to fall on the other line. Hence, the finding recorded by the learned tribunal to the effect that the run over of the deceased by the other train would be covered by willful negligent act and covered under self-inflicted injury as per section 124A of the Railways Act. Accordingly, the finding recorded by the tribunal that the victim deceased had got down at the other side of the platform and was carelessly crossing the other railway line is held to be plausible and acceptable. Hence, no interferences called for in this appeal. In view of the opposite finding that the accidental death of the deceased is attributable to self-inflicted injury as per section 124A of the Railway Act 1989, the presence or absence of a valid railway ticket is of no consequence. This is important. Moreover, as per the evidence of AW2 and AW3, they purportedly saw the accident, got the train stopped, and saw the dead body after being run over by other train, and the AW2 being the son immediately went towards the dead body. The absence of a valid train ticket is quite conspicuous and its loss remains unexplained because as per the evidence of AW1, the train reached the station and the deceased went to bathroom, and after coming out, he was washing his hand and face at the time when he slipped out of the train. The said situation leads to a presumption that the railway ticket was definitely was not being held by the deceased in his hand as he was washing his hand and face. And as such, there is no way that only the ticket would be lost or misplaced at the time of accident. Hence, no interference is called for in respect of the finding of the relevant timely. This judgment I am relying on only for the purpose to bring home the aspect that even if it is assumed that the deceased was inside the train and he had fallen down, as per the report of the DRM, my lord, he was sitting on the steps, and that was a negligent and careless act. Like, if he had suffered, it was because of his own negligent act, my lord. I'm not saying that actually that had happened, my lord. My main case is, my lord, there is no evidence to prove at all that he had fallen down from the train. Now, this aspect has come in the report. This report is also speculative. They have just speculated that he might have stood out there in that position and might have fallen down. It is not based on any evidence because nobody has seen how the person had fallen down from the train. So it's a case of no evidence at all. That is my first submission. Even assuming that he was inside the train and he had fallen down, it was because of his own negligent and careless act, my lord, and that would come under the purview of section 123A(b), and no compensation is payable in this case. That is my submission. And the injury sustained by the victim, that is very relevant, my lord. A person falling down from a running train, my lord, cannot sustain that kind of an injury. And these aspects of the matter was discussed in Kaliram's court judgment. Negligent that has been discussed in this Saraswati Dasa judgment. The other two judgments which I have relied, they have followed the. That's my submission.
Lordship, I am submitting. Reply. Lordship, kindly see. My basic principle is that facts admitted need not be proved. They have admitted that the deceased fell down from the running train. And moreover, journey ticket was recovered from the possession of the deceased. Ticket has been exhibited.
Yes.
So it is established that he was a bona fide passenger and he fell down from the running train. It was an untoward incident. So far as carelessness or negligence is concerned, Lordship, kindly see the judgment on Supreme Court.
They have already given a
Lordship, the judgment is there.
Then okay.
Even if there is negligence on the part of the deceased is entitled. The claimant is entitled. Compensation. Lordship, can you see? Supreme Court judgment. 2011 1 TSC 10 SC. 11 paragraph 5, Lordship. From the bottom, can you see? I have marked it, Lordship. Secondly, even if it were to be assumed that the deceased fell down from the train to his death due to his own negligence, Lordship, got it? It will not have any effect on the compensation payable under section 124A of the Act. Even there is any negligence on the part of the deceased, then also the claimants are entitled to compensation. Lordship, other judgments are there, Lordship. And it is strict liability, Lordship. Whether there is any negligence on the part of deceased or on the part of railway authority, it is not relevant, Lordship. Lordship, another judgment, Supreme Court, Lordship.
So again, you are starting.
Lordship, it is there, Lordship. Another judgment. Strict liability.
You have to produce the judgment that your
Paragraph 17, Lordship. Section 124A lays down strict liability or no fault liability in case of railway accident. Hence, it is a case comes within the purview of Section 124. It is wholly irrelevant as to who was at fault. Kindly check paragraph 17, Lordship. Kindly see. Section 124A lays down strict liability or no fault liability
I'm not disputing all this.
in case of railway accidents. Hence, if a case comes within the purview of Section 124A, it is wholly irrelevant as to who was at fault. Even if there is negligence on the part of the deceased, the claimants are entitled to compensation. So, for other parts of other submissions are concerned, as submitted by the other side, one judgment judgment that the dead body was lying for more than 1 day. Learned tribunal held that there is delay in finding out the dead body in the place. But even there is delay of more than 1 day, it is irrelevant. Two judgments are there.
I'll not trouble your lordship by reading out the judgment. I'm just handing over. It's an apex court decision as to how the nature of injury is relevant. Lordship may short judgment. I'll not read it out for lordship's convenience. I'm it's
The Delhi High Court judgment, Lordship. First one. Lordship, kindly see 2014 4 TAC 547 Delhi. Relevant paragraph at paragraph 10. Lordship.
These are not binding on a high court.
Lordship, the final conclusion of the tribunal is that since the cut-up body of the deceased so-and-so was lying on the adjoining track, it would not be possible for the deceased to have fallen from a running train. In such a case, his body would not be discovered in cut-up position in the in the adjoining tracks. Once again, this conclusion, in my opinion, is totally misconceived because issue of cut-up body lying in the track, whether the same is on account of fall from train or a person being run over by a train, depends upon the facts of each case. In the present case, as already discussed above, the deceased was traveling the train and he has been adequately proved, so it has been able to throw the statement so and so, so and so, so. No doubt, a question arises is that how is the body of the deceased found lying in a carved up position in the adjoining railway tracks. To this, I would like to state that adjoining to the tracks, there are many equipments and poles of the railway. If a passenger falls from the train in which he is traveling, it is always possible that his legs gets entangled at the steps at the door from which he falls, and on account of the accident, including his coming partly under the same train as also they are hit by other equipment poles adjoining the tracks, the body can surely be surely in some cases be bound in a cut-up position. The adjoining track, in the adjoining track, no one can exactly prepare a trajectory of the body following from a train, getting entangled in the steps, hitting the railway equipments, and in the final place where the body is found. All these dependent upon the facts of each case. Therefore, I am the opinion that the tribunal erred in holding that merely because the body in cut-up position lying in the adjoining track, the deceased was not a bona fide person and he did not fall from the train. The facts of the case now, the deceased was a bona fide traveling in the train and fell down from the train, and that is an untoward incident happened, and as per provision section 123 of the section 124 and 124 of the Railways Act 1989. Once falling a passenger falls down from the train, what would be the position of the dead body? One cannot say. One cannot prepare an exact trajectory. What is the position of the dead body? The deceased fell down from a running train. Maybe injury may be caused on different parts of the body. The position cannot be assumed or cannot be said that in that position he should be in that position. It's a case of murder or something else. There are other Potime Court here and the judgment. Is the case of Delhi High Court. Delay in finding the dead body, Lordship. Paragraph 6, Lordship. So far as the argument of body of the deceased found more than a day later, and for which purpose a timetable of Nilachal Express train was relied upon in which the deceased was travelling, I cannot agree with such argument and agree with the conclusion of the Railway Claims Tribunal that once a person dies, it is not possible to exactly find out and reconstruct the chain of events to execution, as no dependent was travelling with the deceased. Tribunal rightly noted that once the deceased was bona fide passenger, compensation has to be given because the deceased was found on the railway track and the delay in finding the dead body or reporting of the incident cannot take away the incident from being an untoward incident, and consequently the liability of the appellant railways. There are two judgments also, Bombay High Court, Bombay and here in this case, the paragraph 6, Lordship, of Guwahati High Court judgment 2014 3 TSC 406 at paragraph 6. The learned tribunal has not considered the said report at all. While it is the finding of the learned tribunal that Kamakya Express train did not ply between the landing and Guwahati that day, there were other trains on the track, and merely because the name of the train was wrongly mentioned by the related claimant, the learned tribunal should not have taken such a technical and pedantic stand so as to reject the claim of the father who was lost his son. By definition 123 of the Railways Act, when a passenger falls from a moving train, it comes within the purview of untoward incident, and in that even railway becomes liable to compensate the death. That is, what is admitted in report submitted by the investigating authority has not been considered by the learned tribunal. After holding the victim was not a bona fide passenger of the train, the learned tribunal did not decide other issues. Because here in this case, even the claimant side wrongly stated the train number or name of the train. Then also, the claimant, if he is a bona fide passenger, then he is entitled to compensation. See, here, as per section 24A, accidental falling from train. The victim was traveling with general ticket. With general ticket, he may travel any train on this route. So, if the claimant had wrongly put the name of the train or number of the train, it is irrelevant. Fact is that he was traveling in a train. So my submission is that facts admitted need not be proved. They have admitted that the deceased fell down from the running train. The other side is taking the plea that there is negligence on the part of the deceased. Even if there is negligence on the part of the deceased, that claimants are entitled to compensation. And they took the plea that in their lordship kindly stated that cross examination. Nothing in their cross examination, nothing contrary could be. They could not find out any contrary. Not a single question asked about the bona fideness and falling down from train. Admittedly, he was traveling a train, falling down from the train and sustained injury, and he was having a ticket. Ticket was recovered from the position of the deceased. Their inquiry report shows that he was a bona fide passenger and falling down from train. So, judgment and order passed by the Grand Tribunal may be set aside. And
Just if I may add, just one word, my lord. If the negligent act results to injury, it would amount to self-inflicted injury. That is what I'm trying to impress upon. That would come under the exception. And that is not my main case, my lord. The report itself is speculative. The first thing is the onus lies on them. They have not been able to discharge their initial load.
No, I have said also repeatedly that facts admitted need not be proved. They have admitted that he was traveling in train and falling down the from train, running
Just
train.
speculation without any.
They have
I have had. Case much.
Possible result is yes. Much of. Value.
May I please the lordship? Here in this case, the objection has been filed. Probably Hoshi remembers this application. The one IA has been filed. This appeal has been admitted, and accordingly, this status quo order has been passed by the Honorable Court. Now, there is an apprehension on the part of the petitioner that there is probable attempt on the part of the opposite parties to violate that status quo order.
So you
for
want
that
any
reason,
police order?
yes, lordship, for that reason, police protection. Now the affidavit has been filed. Lordship can peruse the particular affidavit in opposition. In the affidavit in opposition, they have merely denied all the allegations that whatever we have stated in our IA is not correct. These are all based on denial. The entire affidavit in opposition. Now the factual aspect of the matter is that lordship, this status quo order is with regard to the fact the person who is in possession, he will retain that particular position. So if the plaintiff is in possession of the total plot of land, which is the scheduled land of the plaintiff, and I will retain that possession, and the defendant is purportedly claiming that he is in possession, although there is a sale deed with regard to that. But if he is denying that sale deed, or he is saying that no, the two defendants are there, we are in possession of this suit land. So they are in possession. So there is no dispute with regard to that fact. And who is in possession, who is not in possession. Only thing is that status quo order has been passed by this Honorable Court after assessing all the material facts, and based on the submission, based on the contents available or the materials available on record, the status quo order has been passed. Now, since the order is in force, in that view of the matter, the limited prayer on the part of the petitioner is a very innocuous prayer, lordship, that some direction, because being a common man, it's not possible for the plaintiff to resist the defendant or his man and agents to come inside the suit land and to encroach upon the land or to change the nature and feature. So this application has been filed. So the defendant is not going to be prejudiced in any way. And if the prayer of the petitioner is being allowed, this is for the purpose of proper administration of justice, just for a direction to the concerned SP or the concerned police station to enforce that it should not violate the order in any way. That is the very limited prayer on the part of the petitioner. I don't think my learned friend or the defendants are going to be prejudiced in any way if the order has been passed. So this is the very limited prayer with regard to this IA is concerned. Because if it is not passed at this stage, there is every probability, because they have already denied. If it is in opposition, they have denied, because it is the specific stand of the petitioner or the plaintiff that I am running my business from that particular land when the possession was handed over by execution of a unregistered deed of sale. And since then I am in possession. Now they are saying that you are never in possession. So they have already created a structure that I am not in possession of the land. So if the status quo order is not enforced at this stage, after a certain period of time, they will encroach upon my land, and this will completely change the nature and feature of the suit. Because if they are claiming they are in possession, well, very good, they are in possession. Since I am claiming I am in possession of the land, so if this order is being passed, this is not going to hamper or prejudice their interest in any way. Because this is not an injunction. Restriction order was